May I please, Lordship? Lordship, I wish to mention item number 12 of the daily list, Lordship.
Item number 12.
12, Lordship. We were supposed to collect some link document, Lordship.
Sorry,
We were supposed to.
let the item be called. Yes.
Listing detail.
Any more mention?
Item 1 for motion.
My lord, in this case, the school register was supposed to be placed, my lord.
Sorry,
The school register was called for, my lord. My lord,
it's available or sometime.
sometime, I think.
It stated that as per the order of 5/6/2023, the admission register in origin of Dumergudi LP school was required to be produced. Same is not available, adjourned. It may be produced on the next date.
Item 2.
Item 2, my lord, I was. Report, I was supposed to get the report, my lord. But I'm
Till the
sorry, my
next
lord.
date notes, SP to make
Yes.
a verification of petitioner proceeding Motiur and Motiur Rahman, son of Abdul Kalam Nabi Khatian. Same
My lord,
person.
I pray for 1 week more time and copy of the order. my
Mr.
lord.
J.
Copy was-
Paying, Land Council of Home Department, prays for some further time for the verification report as required by the order of 25/5/2023.
Copy of the last order, my
A
lord,
copy of the
because
last order be, a copy of the order 25 be also made available to Mr. Paying.
Obliged.
Item 3.
Yes, madam. Item 3.
here also school register was called for, my lord. In fact,
I got the information, they are on the way.
On the way.
Yeah, on the
they
way.
have to.
Day after tomorrow, Lordship.
Sorry,
Day after tomorrow. Lordship. Day after tomorrow. right.
Set.
Monday, Lordship.
My lord,
Monday.
in fact, the teachers were coming, my lord.
On the
But
way.
on the way, but they stuck in some.
educate through the regular produce origin admission. When you want,
Monday,
Monday, Lordship.
we'll keep it.
on the
You-
prayer of MSS Corn and Education Department, list again also.
19 June.
Deep diver.
Item 4.
Kindly clear the last order of this.
Yes, Mr. Petitioner relies on the voters list of 1966, so village.
Yes.
Complete voters list. Where is it? The election department was required to produce a complete voters list of village Sindurai Part 2 of the years 1966, 1971, 1985, and 1997 for examination of the court. None appears for the election commission when the matter is called list on Swinson for the voters list.
Item 4 for admission.
May I please the lordship, the youngest counsel of this case is another court. Matter will be taken up after some time. Yes.
Item 6.
Is a microphone on? Just please check up microphone.
In this case, Lordship has directed to constitute medical board
Huh.
and a report is required.
Hmm.
So Mr. B. Gogoi will appear because he has the instruction.
I'm
After
giving
some
it a
time.
After some time, I will.
Yes,
Items-
Mr. Kolita, what happened? Has the boy been taken to
Yes,
the?
yes.
Yes, yes.
He has taken, he has been
Yes, sir.
taken. It's okay.
Item 7.
This item 7, notice. Cancer patient. What's the age of this person?
At present, not.
And I think last date we required an update, whether it's in
Yes.
some kind of a terminal
Age is
stage
43
or,
years.
sorry,
43 years at present.
what is the stage of the cancer? Terminal stage or preliminary stage?
Not preliminary because he can't walk properly. I spoke to him. But because of financial constraint, again, also he was referred to cancer hospital. He is not coming. He's only taking treatment from Sonapur district.
Treatment
hospital. cancer.
No, he's taking treatment in Sonapur.
Sonapur District Hospital, but as per the
Do
doctor.
they have any facility?
They don't have much facilities, but he couldn't come to
Guwahati.
Biborua. There is no one. His wife also doesn't survive.
Yes, Mr. Pine. What is the difficulty in coming to Biborua? They need money.
Money.
How much money? How
that
much
is-
money is required in Biborua?
That's why, my lord, the legal service authority, we have the. they
That's
have
what
the
I'm
facilities.
thinking.
Yes.
How much money is required?
Exactly, I'm not aware, Lordship, even,
It's also a government of India institute.
but
Do they
subsidized
charge
rate, yes,
on a commercial?
subsidized rate has to be
They
paid.
start on a charge on a commercial
No,
basis.
Not commercial basis, but subsidized rate has to be paid. Even for any test and all, subsidized rate has to be paid.
Government of Assam has some schemes, I think, for cancer patient.
Yes, Lord. There is Atal Amrit Abhiyan is there, Lord.
So now will the question be whether he's a foreigner or not? So whether we should give the benefit? Will you raise that issue?
My lord, let them treat first, my lord, in the hospital. The legal, we have the legal service authority facilities from legal service authorities, it can be provided. So let this case be.
No, legal service authority may not have that provision to provide for even those subsidized rate of a cancer treatment. For the health department. Yes, Mr. B. Gugoi. No, that is another matter. This matter, this is a person who is proceeded under the Foreigners Act, 43-year-old, cancer. Is any facility available to give him treatment?
Yes, madam, there is a super specialty in cancer, madam, in Guwahati, GMCH, madam, newly established.
Is it very expensive?
Madam, otherwise, madam, there are certain schemes, madam, under which he will get a free treatment.
No, she is saying that he is even doesn't have the money to come to Guwahati also. So he is attending to some district hospital in Sonapur,
Lordship.
who doesn't have all these facilities.
But that I can, madam, I can have the instruction, Lordship may take up tomorrow in that case, or at 2, madam.
Just see if this person can be given a treatment.
If he is a declared foreigner, probably, madam, he will not come under the scheme. That-
No, tribunal had declared.
Then, madam, some difficulty, but let me have instruction, madam. At 2 or after 1 hour, madam, I will have that.
No, but health is
Of course.
Article 21. It's
21
applicable even to a
I
foreigner.
understand, madam.
But again, the question is whether those subsidized treatment he'll be giving or not. No, that is, of course, subsidized treatments may be only for citizens. It may not be for.
If he
Anyway,
is
you-
under custody, my lord, in that
Sorry?
case, if he is under custody or detention, in that case, my lord, the detaining authority will have to do that. Ultimately, it will burden on the.
Instead of
government, my lord.
deciding, why don't you go to a detention
Yes, sir.
camp? Moment you are in detention
Yeah,
camp,
of course, they have.
you will start getting that treatment.
Already
Sorry.
he is on interim. As per order dated
Okay,
26/10.
we do one thing, let us recall the interim order. Moment it is recalled, he'll go to detention center. And the day he goes to detention center, Mr. Gogoi will assure that he'll be put up in the hospital for treatment.
Die peacefully outside the detention center if without
No,
treatment.
Ghosh, why don't you understand what we are saying? It's for your benefit. Being a foreigner, he possibly cannot avail the subsidized medical facilities being provided.
Yes, Lordship.
But if you are taken to detention, once you recall the interim order, then they will be under obligation to give you the treatment. So the very day,
Yes,
they will shift you to the hospital, get your treatment. It's more human approach to the person. But if you don't, if you are outside, you are not entitled to be subsidized. That is their stand. We wanted to, more
I
than
got the
deciding
point.
your citizenship for the time being,
Yes, Lordship. I
we are
understood.
having a more human approach towards this
Because of
person.
his, yes. Yes, Lordship. I got it.
First, see whether he can be given some treatment or not.
Let me get the.
So what kind of a
up-to-date
better
his
approach can
medical-
you
I
think of
understood,
this?
Lordship, I understood.
From the
So
court
let
side
me-
and even from the side of the state?
Let me get his, what is his updated stage, because the documents which I have.
And if he
annexed-
does not need a treatment, of course, it is a different matter. We'll decide it on merit.
Yes, Lordship, let me get his updated medical documents, Lordship. The documents which I have annexed is of 2021.
From our hurt, no one likes when a person is suffering.
Yes, I can understand, Lordship. Let me talk to the client and get the
But
stage.
technically, they say that it is a
Understood.
possibility that once they are in their custody, they'll be bound to give the treatment. Then you'll start getting it.
Beautiful.
Understood, Lordship.
It's one right under Article 21
Yes,
versus another right. You choose which right you want to avail. It's your choice. One of your right under Article 21 is to remain out of detention center. You want to choose that right and suffer with your illness? Or you want to choose the other Article 21 that they'll
Right,
give
right.
some kind of a
Yes, Lordship,
treatment?
I got it. Let me just get his updated medical condition right now, because it's of 21. What is his condition or stage?
But otherwise, this will be a much larger issue. Whether a declared foreigner can be given the
Yes.
benefit of the subsidized treatment.
Yes, Lordship.
It will take a long time to decide those issues. In the meantime, this man will suffer.
Yes, Lordship.
You just talk with Mr. Gogoi and Mr. Pahing, talk with the client, take a call. If you want our help,
Yes, Lordship.
the orders
I
to be
got it.
passed in any manner, we are
Yes,
there
yes, Lordship.
for the purpose. Or you want to get it decided on merit today itself? This is another way out.
Yes, Lordship.
But is the matter so overwhelmingly in your favor that we can declare him to be citizen today itself?
I have only one document. Only one document.
Then,
I don't have any other, because as a destitute child, he was grown up.
then this will require some further hearing.
Yes, Lordship.
But if your case is so overwhelmingly in your favor,
Yeah.
so
with
that
the-
today
with
itself we can hear and dispose it of,
I can understand.
we can do that.
Lordship.
But even that is also not there.
Not there.
Then
Only one issue is there. It means
Hmm.
only one document.
three ways out.
Yes, Lordship.
One, you take your own medical treatment
Yes,
as
Lordship.
per your capability. We'll continue with the interim order. He'll not be in any detention.
Yes,
We'll
Lordship.
defer the hearing. Two, it's a very, very technical way
Yes,
approach, of
Lordship,
course,
definitely. I had to admit
that
to that.
you, once a interim order is recalled, they are bound to take you to their custody, and once they
Yes.
take you to their custody, you'll be given all the treatment. Three, we decide on merit. On decide on merit, we can't do it today. As you say, you don't have the documents and all.
He tries to prove only through birth.
Hmm.
Only one document.
Timing, we are more concerned is the health of the person rather
Yes,
than this his status and all.
Let me just talk to the client once. Lordship.
So once a situation is brought to the notice of a constitutional court, it's a duty of the court to look into the health aspect of a person.
Yes, Lordship.
In furtherance thereof, what we are saying, what we are indicating. Take your call. Sometimes hard calls are required to be taken in life.
Yes,
What to do?
Lordship.
Mhm.
Just, I may be accommodated for the day. Let me talk to the client.
What a day.
Yes, so that,
And you, Mr. Gogoi,
Yes, sir.
she wants your help. please.
Lordship may give a date matter so that I can be present if required on the next
Hmm.
day. Date is given, I will.
Let it come on Monday.
Monday
Monday.
is agreed. File another petition as well as the respondents list from Monday.
Oh, like
deeply obliged.
Seven.
that.
Item 8.
My lord, 66 voter list at page 20, page 27. Village Balogora,
Page number,
page 27.
page number 27.
The names are at page 28.
Ba-
Ziauddin is the grandfather.
Balogora village,
Yes, ma'am, Balogora.
66. Ziauddin grandfather,
Grandfather.
Payam Nessa grandmother.
Well, yes, madam.
Okay, now who is the
My
father?
lord, father is at 85 voter list, page 29. In same village,
Fakir
Balogora.
Ali.
Balogora. They are all along in Balogora. My lord, here,
Yes, Mr. Pai?
My lord, it is accepted, my lord, they are all along in my lord, in the same village. My lord, but neither in the, my lord,
Together you are not saying.
not same.
And the answer he'll give is the certified, complete certified copy is not given to us.
No, but if they can produce the entire voter list. my
And
lord,
that would have been more helpful also.
Yes. that can be well.
Can you produce the complete
Yes, ma'am.
voters list, all in between complete voters
Yes, ma'am.
list? Because at some stage, there is a possibility that Amir Ali and Fakir Ali name may appear together.
Yes, madam.
Yes.
2010,
Yeah, like-
1985. Say in 1997, it is a possibility that it may appear together. For effective adjudication, the petitioner to produce the complete voters list of all of village Balogora from the years 1966 to 2010.
My
Item 9.
Item 9. Yes, Abdul Rahim. Petitioner may produce a complete voters list also. So Gambura Ranjit Bhuiya to file an affidavit there. You are Hussein. Hey, Hussein. You are relying on the evidence of the Gambura. You are relying on the evidence of the Gambura.
My lord. My lord, there is another evidence also, my lord.
Forget about your another evidence.
Yes.
You relied on the evidence of the Gambura, who had deposed their grandfather is Rahim. Kindly go through section 50 of the Evidence Act.
My lord, in the affidavit in seat, my lord, the
Mr. Counsel, kindly go through section 50 of the Evidence Act. You don't want to go through.
at this moment.
Read what is provided in section 50 and then read the evidence of the Gambura. Whether section 50 is satisfied or not.
My lord, section.
50 of the Evidence Act. Yes, Mr. Henry.
Lordship.
Affidavit of the Gambura. Mr. Hussain, please read section 50.
My lord, opinion on relationship when relevant. When the-
Sorry, read slowly. What?
Yes. When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of
Such relationship.
Yes,
You are claiming that your father is so-and-so and grandfather is so-and-so. You are claiming a relationship. How it can be established? Read further.
or any person who
As a member
as a
of
member
family.
family or
So
otherwise,
Gambura is definitely not a member of family
my lord.
or otherwise.
Yes,
He comes with the expression otherwise.
Mm.
Has
has a special
special means of knowledge on the subject.
is a relevant. fact.
So does the evidence of the Gambura reveal the special means of knowledge? Moment you want to establish a relationship with another person through the evidence rendered otherwise
Right.
of a person otherwise, there is a requirement to satisfy that the other person has special means of knowledge on the
Yes.
subject. Does the affidavit of the Gambura, evidence of the Gambura reveal the special knowledge? No. This is why we are not accepting it.
Let another evidence, my lord, my grandfather, my lord,
Sorry.
my lord,
So you discard Gambura. You are not in.
my lord,
Okay. Now what further evidence you have?
my lord, my kindly see my lord, voter list of 1970 first, my lord.
1970.
Yes, my lord.
Page number
Page number 19, my lord.
19.
My lord, Hussain is my grandfather, my lord. Hussain
Hmm.
Ali. Now another, my lord, serial number 55, my lord, Qadar Ali, my lord. Qadar Ali also, my lord.
Kondor Ali.
Yes, younger brother of Hussain Ali, my lord.
He is a Kondor Ali is the son of Sabed.
Sabit. That means,
And who is the father?
my lord, father is my lord,
Hussein Ali.
yeah,
Hussein
Ali is the
Ali.
grandfather, my lord, of the petitioner.
Sorry.
Hussain Ali is the grandfather of the petitioner.
Hussein Ali is the Abdul Ali is the father.
Yes, my lord.
So how Kandhar Ali?
Qadar Ali is the, my lord, younger brother of my grandfather, that is Hussain Ali, my lord.
Okay. Hussein is the grandfather, son of Sabed. Kandhar is the younger brother of
Hussain
Hussein.
Ali.
Okay, very well.
My lord, this Qadar Ali, my lord, deposed evidence.
Sorry.
This Qadar Ali, my lord,
Ha.
he deposed, my lord, before the tribunal, my lord. That is, my lord, page 59, my lord.
Page 59.
Yes, my lord. Annexure 19, my lord.
57.
Qadar Ali, my lord. There also Qadar Ali, that is.
Yes, Mr. Pine, what do you say about the evidence of this one? It's aged 87. And date of the evidence is, I think, 2017. In 1970, he was 40 years. So in it's 2017, he was 87 years and he writes 87 years. Mhm. And here the section 50 is satisfied. That special knowledge.
97, 97, the voter list of Abdul Ali.
No.
And
But the evidence of Kandar Ali takes care of everything. Kandar Ali says Abdul Ali is the son of Hussein, his elder brother. And the petitioner is the son of Abdul Ali. So voters list is no longer relevant. Go back, cross-examine this man. That's all you heard, Mr.
Yes.
A. Hussain, Land Counsel for the petitioner. Also heard. You are also appearing, as well as Mr. J. Handick, Land Counsel for the Revenue Department.
My father also deposed.
Sorry,
My father also deposed.
your father himself is doubtful whether he is citizen or
Yes.
not.
That is
How will it help you? Only saving grace is that Kandar Ali. Abdul Rahim had been referred to the Foreigners Tribunal number 4, Nogao, at Juria, for rendering an opinion as to whether he is a foreigner within the meaning of Foreigners Act 1946, resulting in registration of FT case number 264/16. The tribunal rendered an opinion dated 24/4/2019 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1970 of village Boguriguri, police station Rupohihat in the district Nogao, which contains the name of Hussein, son of Sabit, at serial 53. As well as that of Kandar Ali, son of Sabit, at serial 55, where both are shown to be residing in the same house number 11. Petitioner claims that Hussein, son of Sabit, of the 1970 voters list of village Boguriguri, is his grandfather, and Kandar Ali, brother of Hussein, is his, what do you say? Is the younger brother of his grandfather. No, he was also grandfather. Where is the 1997 voters list?
97 voter list, my lord, page
22.
23, my lord, page 23.
The petitioner thereupon relies upon the voters list of 1997 of village Boguriguri, which contains the name of Abdul Ali, son of Hussein Ali, at serial 8, and claims that Abdul Ali is the father of the petitioner. To establish that Abdul Ali is the father and Hussein of the 1970 voters list is the grandfather, petitioner relies upon the evidence of, where is the Gaungura?
Gangura, my lord, page 59, my lord, Gangura is, my lord, page 64, my lord.
Relies upon the evidence of Ranjit Bhuiya, who is claimed to be the Gaungura of which village?
My lord,
That is also blank. Who is claimed to be the 49 Abdul Rahim.
in the certificate, it is reflected, my lord, page 45. He issued a certificate, Gaungura issued a certificate.
Is a Gaungura of which village?
Podamoni town, Podamoni, Pathas, Adakhanda, and Boguriguri, my lord.
What did I say? Is also the Gaungura of village Bogoriguri. Then who is Abdul Rahim? Page 49.
49, Abdul Rahim is my lord, Tosidi, my lord, petitioner, my lord. Petitioner, my lord.
Hmm.
Petitioner, my lord.
Gaungura. The petitioner also relies upon the evidence rendered by Kader Ali, son of late Sabed Ali of village Bogoriguri as DW3. Other one was Ranjit was DW4. DW4, they are writing as OPW. OPW4 and this one is OPW3. Kader is OPW3. By relying upon the evidence of OPW3 and OPW4, the petitioner claims that he has discharged the burden that Hussain of the 1970 voters list is the grandfather and Abdul Ali of the 1997 voters list, both of village Bogoriguri is the father. It is taken note of that the petitioner seeks to establish. Can you give us back our book?
Right.
It is taken note that the petitioner seeks to establish a relevant fact through the existence of a relationship, that is, with Hussain of the 1970 voters list as grandfather and what Ali it was?
Kandar Ali, my lord.
Not Kader Ali.
Kader
Your father?
Kader Ali,
Your
my lord.
father. Name of your father.
My father is Abdul Ali, my lord.
And Abdul Ali of the 1997 voters list as the father. The procedure to be followed in establishing the relationship of one person to another is provided under Section 50 of the Evidence Act, which is extracted as below. A reading of which is extracted, quote Section 50 of the Evidence. A reading of Section 50 makes it discernible that when the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who, as a member of the family or otherwise, has special means of knowledge on the subject is a relevant fact. In other words, we have to examine as to whether OPW 4 Ranjit Bhuiya had any special means of knowledge on the subject that Hussain of the 1970 voters list is the grandfather and Abdul Ali of the 1997 voters list is the father of the petitioner. A reading of the evidence rendered by OPW4 Ranjit Bhuiya does not make it discernible that it indicates that the witness had any special means of knowledge on the subject. From such point of view, the evidence rendered by OPW4 to establish the relationship would have to be rejected. On a reading of the evidence of Kader Ali, OPW OPW 3 Kader Ali, it is noticed that the claim is made that Kader Ali is in fact Kandhar Ali of the 1970 voters list, who, by virtue of being the son of Sabed, is the younger brother of Hussein of the 1970 voters list. If it is to be accepted that Kader Ali is the younger brother of Hussein, the requirement of having a special means of knowledge on the subject prima facie appears to have been satisfied by OPW 3. From such point of view, matter remanded back to the tribunal to examine the evidence rendered by OPW 3 Kandar Ali, son of late Sabed of village Bogoriguri. For the purpose, the Home Department may cross-examine OPW 3 in any manner as may be advised, so as to extract the veracity as to whether OPW 3 Kader Ali, son of late Sabed, is in fact Kandhar Ali, son of Sabed of the 1970 voters list of village Bogoriguri. And secondly, whether the evidence rendered by him is factually correct. Upon doing the responding Home Department may also make their own verification and submit a report before the tribunal. Upon doing the needful, a reason order be passed.
My lord, may I have a submission, my lord? This Kandar Ali, my lord, had already died,
Sorry?
my lord. This Kandar Ali, my lord, had already died, expired, my lord. In the meantime, my lord, 3 years back, 3 months back, my lord.
Then what can you do? Mr. Pine, then what can you do? But his evidence remained, you know, that cannot be discarded. It is stated that Kandar Ali had in the meantime died. If it is so, as the state will not be able to cross-examine the said witness, the Home Department may make their own verification inquiry of in any manner as may be advised and submit a report before the court. And such report, if submitted, would be considered to be in the nature of a cross-examination of OPW 3. Sorry.
If my learned friend can produce before the tribunal, my lord, that's some more voter list of Kader Ali, because Kader Ali after 66, he has not produced any voter list.
For the purpose as submitted by Mr. J. Pine, the petitioner to produce the subsequent voters list containing the name of Kader Ali,
Along
so
with
as
his-
to verify whether he had existed up to the year 2017 to render the evidence, as well as the death certificate of Kader Ali.
Yes. Lovely.
Item 10,
Because if Kader Ali died before 17, that this must be some other person. So you make your verification.
Another issue, my lord, there he said the father, his brother died 10 years back. But 97, 93, the brother is not existing along with the.
So find out, make your own verification. And your report will be take
Yes,
the. Yes, Mr. Khan.
Kindly peruse the order letter 31.
That some information has been received and the learned counsel is for some time to examine the same.
It's maybe- My lord, but take this matter tomorrow or day after tomorrow, probably.
Adjourn on the pair, Mr. J. Pine, on where to be listed also.
23rd. Item 11 orders.
Lordship, the matter may be passed over for the time being. The learned senior advocate is on legs in court number 1, Lordship. At 2, Lordship, or
Let's see.
at 2, at the end of the list.
Fixed time, we don't know. We'll see.
The matter was earlier heard by you.
Sorry,
Day before yesterday.
The day before the matter was heard.
Custodial death matter. no?
yes, we are aware of it.
Well for hearing.
But as per the dated my lord,
Mhm.
29/5, my lord. I have applied for the certified copies, my lord.
You applied for some certified copy
Yet to be received. my lord.
of what? May produce. It stated that as required by the order 29/5/2023, some certified copies had been applied by the petitioner, which is yet to be made available. In view of such statement, list on strings. Statement of Mr. K. Kolita.
3 weeks.
Yes, the item 13.
Item 13.
In this case, on earlier occasion, directed us to produce the
Complete voters 70 and 79,
original complete notation.
want some time.
Oh,
Mr. A. Ali prays for some further time to produce the voters list of 1970 and 79 as required by the order of 29/5/2023.
Item 14.
may please.
Page
My lord, in this case, 1958 brutalist lordship. will
the
find
page
case
number
23,
23.
my lord. Jahid Ali, my lord, grandfather.
Nupur Jat Grant.
Nurpur Jut, Grant.
Nupur Jat Grant.
Nurpur Jut Grant. My lord, page 24, Jahid Ali is the grandfather, Abed Ali and Zulekha Bibi are parents.
Abed Ali father.
My lord.
Jahed grandfather. Very well.
And Zulekha Bibi mother
So
was.
now how
examined.
will you prove that Abed is the father?
My lord, no brutalist with parent, but mother was examined. And
Mother is Amker.
my lord, Zulekha, my lord,
Zulekha. Zulekha is the mother. Okay.
was, he was examined,
Mother was examined.
examined. And
Any voters list of the mother and son together?
my lord, she's daughter, not son, my lord,
She's
Son.
daughter,
his daughter,
married.
married daughter.
Where is the evidence? Zulekha
My
Bibi?
lord, at page annexure 11, page 41,
Mhm.
evidence in C. Our process.
Page 41.
41.
Zulekha. How a person can swear an affidavit stating that Zulekha Bibi, alias Zulekha Khatun, alias Jeleka Bewa, alias Januk Khatun. How can you file an affidavit in that manner?
My lord, that has been
The
done by
person
the lawyer, my
actually-
lord.
Person will actually one name.
Yes,
And the affidavit can be only in one name.
yes, my lord.
In the affidavit, you can explain
That
that
should be, my lord.
although I am Zulekha Bibi, some people also call me by this
Yes,
name.
That should be, my lord.
But your identity cannot be 4 different names. Never.
That is, I admit, my lord.
So how can you take
My
note of
lord,
this affidavit?
Yeah, her cross-examination part at page 40.
It may be, Mr. Sigdar. Now we
Hmm?
take this one to be affidavit of 4 different persons or same person, or if same person, which of the 4 persons?
My lord. Her name mentioned as Jeleka Bibi, that at least.
Mr.
that may-
Sigdar, others may call you by some other name, but you are A.R. Sigdar. Can you ever yourself call you by some other name?
No.
Never.
No.
Somebody else may call you by another name.
I admit, your lordship, that has
Hmm.
been,
Then don't
the
you
affidavit
think,
is not prepared properly.
don't you think this is defective? That my husband name, late Abed Ali, alias Obed, alias Abed,
My lord, in paragraph 9 of the evidence in C, there is some reasonable statement.
the person is still
Yes,
alive or
43.
no more?
My lord, the mother perhaps still
No, no,
alive.
mother is still alive. Zulekha Bibi is still alive.
My lord, I have to take instruction, my lord,
Hmm.
but, I feel. It's right. Here, my lord, there is a statement, the Asiya Khatun his daughter. He also named, otherwise also named as Asija Khatun. Then about husband's name, Abed Ali, and her husband also known as Obed. Then about her, my lord, again, actual name of mine is Musammad Jeleka Bibi. I am also known and called as Jeleka Khatun, Jeleka Bewa. So this, when this is available, my lord, the starting of the epidemic not, or not to be in my lord. My lord, Gavura of the parental village was examined. His evidence is found to be, my lord, little convincing.
Yes,
Yes.
Mr. Pine, what do you say? Huh? Sorry? No, what do you say?
My lord,
What is your submission?
in fact, my lord, this evidence is in affidavit has been filed. As your lordship, my lord says, it is in fact defective. But she has stated somewhere. But one thing I'm surprised, my lord, she doesn't know when her brother, my lord, daughter got married.
When a brother got married,
Daughter got married.
daughter got married. She doesn't know. Where is that line?
My lord, page 49, my lord. Second line, and OP is my daughter OP got married, which led so and so, and I do not know in which year the
No,
OP got married.
Please, my daughter, my daughter. I do not know in which year she got married.
Yes, madam.
Possible.
Elderly person, my lord, old age, 80 years old lady.
See, all of a sudden somebody asked you what is on which year your son or daughter was born. You also may be confused. Mhm. Or he may get confused between one son and the other son also. So, but that will not render everything to be discarded. When the evidence is specific, in reiteration, OP is my daughter.
Let him go back and cross-examine the my lord properly.
Heard Mr. Riyaz Shikdar and counsel for the petitioner also. The petitioner Asia Khatun had been referred to the Foreigners Tribunal number 8 for rendering an opinion as to whether she is a foreigner within the meaning of Foreigners Act 1946, resulting in registration of FT bracket 8, case number 1851/2017. Tribunal rendered an opinion dated 24/9/2018 declaring the petitioner to be a foreigner. Being aggrieved, the state petition is instituted in the writ proceeding. The petitioner relies upon the voters list of 1958 of village Nupur Jut Grant, Moza Borsala in the present Sonitpur district, which contains the name of Jahed Ali Sheikh, son of Onu Sheikh at serial 670, and that of Abed Ali, son of Jahed Ali at serial 671, and Julekha Bibi, wife of Abed Ali at serial 673. Petitioner claims that Jahed Ali Sheikh is the grandfather, Abed Ali is the father, and Julekha Bibi is the mother. The Julekha Bibi had rendered evidence before the tribunal as DW2, wherein in her evidence in chief stated that the petitioner Asia Khatun is her daughter. No, the states that she is the mother of the petitioner Asia Khatun, who was born and brought up at village Nupur Jut Grant in the Sonitpur district. She also states that her daughter had later on got married The statement of memory. Yeah. So in cross-examination, DW2 reiterated that the petitioner is a daughter who got married with late Saiful Islam, although she does not remember in which year the petitioner got married. View of the above, remand back to the tribunal to examine the voters list of 1958 of village Nupurjut Grand, as well as the evidence of DW2. The state through the Home Department may further cross-examine DW2 if so advised. The petitioner to also produce the all such subsequent and continuous voters list of Nupurjut Grand for examination of the tribunal upon doing the needful.
Deep level.
Respondents may verify and submit reports.
Item 15.
Wait, please, the lordship matter may pass over for time being.
Time being.
Item
And
6.
To be frank with you, the time being may not come today. We are doing it, but it's most unlikely that the timing will come today.
Item 16 for motion.
16. Yes.
My lord, we got a report just now, my lord. So
Once
can
on
it-
time.
Yes.
Mr. J. Paying, Home Department states that the report of the Superintendent of Police Border South Salmara Mankachar had been received, and the Land Council would like praise for adjournment to examine the same. Pray aloud, list council.
Monday.
Monday. Custody to decide on. Whenever it's convenient.
Deep you right.
Time being item 6.
Where is Mr. Gogoi gone now? Because next time you don't know when it will again come. You have it with you?
Yes.
Yes. Little louder.
Final report, some final report,
definitely.
biochemical and other radiological report yet to come.
You have to. Yes. And
Presently, he is admitted in GMCS. They
Uh-huh.
require some further time to examine and give the
yes,
final
some
report.
psychiatry,
Yes, madam.
neuro something,
And radiology also. madam.
and radiology.
Yes.
Do
So
it-
let it
do
be
it
after
later.
1 week, he is under treatment and they will.
But
give the
now
final
you won't get any physical injuries
That's
because
right.
it's almost 6 years now.
Yes, yes.
After 6 years, what kind of injury you'll find?
2016,
External injury.
Yes,
But the boy is severely affected.
yes, ma'am.
This is the real
Yes,
concern. I think he's psychologically affected, neurologically affected.
So, my lord,
So
I'll
you
let-
examine
Lord, we
and
will
see
post it
now
after
what
2 weeks. In the meantime, if required, we'll place the final report.
how it happened, why it happened,
Yes.
will go a little later.
Lots,
First, take care of the boy,
my lord.
his health wise.
Lots.
An interim report of the medical board has been produced before the court, which shows that the victim boy had been advised for psychiatry. What is the next word?
Till I, if even the, it's microbiology. actually.
Can you read this word? Neuro, something.
Biochemical, neuro. and psychiatry.
এইকেইটা চাই লিখি দিব তেওঁ সুধি ফালে যি বুলি কয় হা এইখিনি And that the final opinion can be given only after receiving the report of biochemical, radiological investigation, psychiatry, and neurology or something. Neurology, that some medical term you're asking. The interim report is returned back to Mr. B. Gogoi, then Council for Health Department, to be produced again on the next date of hearing. And take a little longer.
After vacation in that immediately.
List again for further update.
On 19th.
19 July.
First, take the treatment.
Yes, my lord, as
Sorry.
per my information, he has released on, released yesterday, my lord. Boy was released yesterday. my lord.
Lordship may indicate, my lord, if any further
Yes,
detail is
yes,
required,
that
he
will-
may be.
Mr. K. Kolital and counsel for the petitioner, on the other hand, states that he has information that the victim boy in the meantime had been released from the Guwahati Medical Hospital.
Yes.
We are not observing any view on the boy being released, but what we require is that, comma, if necessary, comma, appropriate medical treatment should be meted out to the victim boy. In whatever manner the medical authorities deemed it to be appropriate.
Obliged, obliged.
A copy of the order to Mr. Gogoi. So the doctors can ask them if
Yes,
they
yes.
think more, whatever is to be done.
Obliged.
Items 17, 18, 19 for admission.
So yesterday,
Got it repaired?
yes, no, there's a new one I got here. Anyway, today it's not a problem. So only thing, your lordship, the 3 points that my learned senior friend has given.
Mr. Chaudhary's submission is that what is contained in the page 48 or something.
Sure.
I think it's page 48. Not 48, 64. Bakija's certificate more than 90 days old. He had made his own submissions why it is unacceptable.
Yes.
Call deposit, it's in the name of the secretary of the society. But whereas under clause 4 ungo, it should be in the name of the society or the NGO. Thirdly, the audited accounts of the year 2017 and 3 years prior to it was not given. Some earlier years were provided.
Basically, these are the 3 points. And
So your reply to Bakijai, what is your submission?
my first submission, your lordship, was that,
No, you have made a detailed submission. Now, for the purpose of recording,
yes, my
what is your submission?
with regard to the notification as well as the NIT. My submission was basically on that because in the NIT as well as the notification, it was never indicated that the Vakizai certificate should be the NIT
NIT and notification.
and the notification.
Do not,
Notification
do not
dated
require,
18 January 2018.
do not require the 90 days period.
That does not reflect here. Here, only thing your lordship is stated is that
Hmm.
Bakizai clearance certificates is to be furnished by the Bakizai authority under the concerned deputy commissioner. And that was basically furnished, number one.
And
The second part, your lordship, that I again argue on that point itself was with regard to the that ARTPS Act is not applicable.
sorry,
ARTPS Act is not
ARTPS Act,
that which they have
that
referred.
reasoning of ARTPS.
ARTPS Act,
Act
90
not
days
applicable.
reason of ARTPS is not applicable because that act has nothing to do in this case. It's an act with regard to public service. The Right to Public Service Act 2012.
Applicable. What is public service?
Basically, your lordship, what went through the act, what was shown in the act is that if I apply for some certificate, look, for example, Bakizai certificate or any certificate from the government, the DC or anyway, so they have fixed a time limit your lordship, that it should be given within 30 days or 60 days. There's a time limit. So if it is not done, then I can approach the higher authority. There is an appellate authority and even a second appellate authority.
Okay, fine.
So that is there. It is nothing. to do-
So two grounds, NIT does not provide prescribe for 90 days, that it should be within 90 days, and ARTPS Act not applicable.
Even the
What is the next submission
next
on the
submit-
Bakizai?
on the Bakizai, your lordship, is that it is that is with regard to the judgments that I will refer or yesterday I referred one judgment. I'll refer subsequent 2-3 judgments where the Bakizai certificate is said to be a curative.
One is that
First was Abu Talib.
Abu Talib.
And telephone after the details.
So
Talib.
A is Abu Talib.
Abu Talib, your lordship, I'll read the.
Abu Talib. We have read Abu Talib
Yes.
yesterday. Go
So
to the
here-
next one, please.
Yes, Abu Talib was said that the requirement is not rigid.
Because we don't want to repeat the same thing
Yes,
again.
exactly.
Because yesterday we devoted almost one half of the day.
Yes. So that Abu Talib.
So
was
the
which was
repetition, without the repetition, you
Yes.
just go forward.
Then I'll go straight away to the next judgment.
Next item, which one?
Murtuza Kumar, New Life Court of Didiba. The division bench of judgment. Division bench are the ones. Oh, it was wrong.
Yes, which one?
Yes, I'm providing a copy of that. This is a division bench judgment of 2022, your lordship, SSC online. Guwahati 731. Here, your lordship, I'm referring to para 10.
Para 10.
10. Then your
Per
lordship,
contra, it's a Mr. D Das assisted by Mr. S Count. Sure. So now what is the ratio? What has been held
so it is held, your lordship.
regarding Bakizai certificate?
Regarding Bakizai certificate, it is your lordship held that the earlier judgment of
Page number,
this is in
paragraph number
para 14,
14.
para 14. it is-
Insofar as Bakizai clearance certificate is concerned,
para 14 and 15. So in the para 15, it says that it refers to Abu Talib. This is sustained.
yes,
So these are the two paragraphs with regard to the Bakizai certificate. These are the two judgments that I'm referring. আমি প্রেসিডেন্টও কথা বলতে পারি। এখন দিয়ে সিঙ্গেল বেঞ্চ ব্যাটিং এখন হল 680
Yes,
then your
para
lordship,
14 we have read. Next,
then one more point that I would like to point out, that your lordship has actually yesterday referred that it cannot be corrected. There is a judgment by your lordship that it can be corrected subsequently, and there is also a division bench judgment.
that curable defect.
It can be cured subsequently, that your lordship has held that. There are 7, your lordship. This is single bench.
There are 7.
7. I'm not reading because I'm going fast, because your lordship just want to refresh the matter. That is why I'm just.
Refresh this. See, sometimes you just have to urge the point, and that point may require a much deeper deliberation. Then we'll go on hearing you, no difficulty.
Yes.
But sometimes that is indication is good enough.
Yes.
So it depends what you are urging.
I'm just providing. the
And if the necessity is there, we'll definitely hear you for days together also. No difficulty with that,
copy to my.
but not unnecessarily.
This same point, your lordship.
Just. Same Dharna Brahmaputra part 1.
They will. They are.
I think this same fishery.
Same people. They are there. We are.
Means every time something happen, everybody is
Varna
before the
Dharma
court.
is a very well-known fishery. They have been there for a very long. We are small fishermen. Your lordship. We could not fight it out. Anyways, your lordship. We do. They got a Xerox copy. That is Xerox Mono Rakiba. Take away the June 149 for the date to judgment 2110. On the same view, your lordship, there's a division bench. That same view has been taken. That was with regard to distance.
Just a minute.
Again, on video.
Yes,
Lordship, this on the
but in
same,
that case, more or less at the same time, they have produced one corrected certificate. So
fact,
in that context, this observation
yes,
was there.
exactly.
See,
Here,
but in the meantime, Mr. Chaudhary has produced a fresh certificate. By there, the defect was not of the period.
Yes,
Defect was, it was issued in the name of the secretary and not in the name of the society.
exactly.
But in the meantime, the corrected one was produced.
In our case,
So we said that the joint secretary was right, that under clause 4, it has to be in the name of the society and not all. So rejection was also right. But as in the meantime, it has been produced, make a limited interference, you also consider that and do whatever is done. After that, what happened? After our order, what happened?
in that case, your lordship,
To
settlement was issued to that particular,
the other party.
to the party who has actually corrected.
Okay, fine.
Then here, your lordship,
So we have got it.
yes, then again on the division bench judgment on the same part, same topic, but this is
Division
not,
bench, which one?
this one I'm giving a copy.
The already referred.
No, this is another one. This is a
Another
division-
one, yes.
Right. Judgment of Justice A.K. Goel Ujjal Bhuyai. This was of 2011, but this is, I'm just pointing it out that this is the copy. I have only one copy. They have somehow misplaced the.
Did we inform the court master?
Yes, yes, we have given. This, your lordship, judgment was with regard to distance. But this is also court said that subsequently you can comply by giving the response. I'm giving my copy of it before the time, before the idiot. I have marked it, paragraph is not there, so I have just tick marked that.
Page the paragraph number,
Second.
No paragraph.
No paragraph numbered. your
Uh-huh.
lordship. In the second page,
second page,
one to third paragraph.
second page. There is no third para in second page in my copy. What is the beginning?
Beginning, your lordship,
First word of the para you are relying?
this is your, while we are in agreement.
While we are in agreement with the
the
view
view
taken by
taken-
single judge today. Okay,
Here there was a direction given to comply with the condition that you give the certificate, distance certificate. If it is complied, then you take a fresh decision. This is one part. Here, your lordship, what has happened? Subsequently, I got the copies of the Bakizai certificate for the period. But that was somehow,
yeah, your Baki certificate.
Yes.
Where is it?
it is not filed, your lordship. It is not before the authorities. I have a copy of that. Copy to Lala. Kali je apne Bakizai three. I'll give a copy. Jo hai two line. We have.
Okay, that is another factor. We'll
there
come
is
to
a-
it. Huh?
there is a lot of miscommunication between the, now what has happened?
So we had taken note of,
I'll give a, I'll just.
you have relied on 4 judgments
Yes,
on the Bakija certificate,
yes,
and yours is a case which is rejected. It is not within a proximity of 90 days from the thing. And that you are saying to justify by firstly saying NIT and notification do not require 90 days. Then you say ARTPS Act is not applicable. These are the 2 reasons of the authority.
Lordship.
Then you rely on Abu Talib.
Yes.
Then you rely on these 3 judgments, Goripur, Gwalpara fishery. Then comes Goripur and one writ appeal 149. Yes. Now next.
Next, your lordship, just I wanted to just submit that point because here actually there was one more certificate issued on 25th.
No, if
of-
it is not there, forget about it. Now your next point.
Yes. Then your lordship, the second point. with
Second point was on your call deposit.
My call deposit. Your
Huh.
lordship. The call deposit was in the name of the secretary.
Hmm.
And that is why I said that is a curable point. If it is in the name of the secretary, then it could be
I
termed
think
as,
that has already been taken care of.
yes. In the judgment.
In the taken care of
2022
para
has-
14 of Gwalpara fishery. The
Lordship,
principle had already been taken care of.
yes, exactly.
Okay, fine.
That is Gwalpara. So that has been taken care of. In para 13 also, your lordship, last paragraph. Para 13 on the same Gwalpara, last
But,
paragraph.
but that was regarding, para 14 was regarding Bakija certificate,
but-
this observation.
Exactly.
What about call deposit?
That is why I'm trying to.
Call
point out.
deposit is,
Call deposit specifically, I don't have a
call
judgment.
deposit is a document of different nature
Yes,
because call deposit indicates who is making the payment to the
Yes.
government.
yes. So I have a judgment. on-
Bakija certificate, whether issued in the name of secretary or society,
Mhm.
that can be interchangeable
Lordship.
as per the para 14 of the division bench. But what about call deposit?
Call deposit, your lordship.
Because call deposit indicates the source of the money that the government is
Yes.
getting.
In the case, your lordship, the case that I will provide, where the court says that it has to be, that the money has to be deposited to the.
That is Mr. Das's submission also.
Exactly, your lordship. That's
All
the
the
decision,
requirement
that's
is money. Don't think from where the money has come.
No, no, not that.
Basically, no, Mr. Das said that. Why not know that?
No, I'm not saying that.
You cannot disturb his submission.
I said it. Call deposit report, judgment to.
He was very specific. We noted his line that it doesn't matter from where the money has come or the requirement is money. Now, what is your submission? Because you also said something of that
No,
nature.
I said that since it is the secretary who has given the call deposit, it is deemed to be on behalf of the society. It is not any other person. My submission was on that.
Okay, a little different.
in
It
my
is-
submission,
it
there
is
is a
society
difference.
that means has to be construed that it is on behalf
Yes,
of
on
the
behalf of
society.
the society, because the secretary has furnished that. In my learned senior friends. case-
Suppose,
Hmm.
no, there is a difference, Mr. Mannan.
Lordship.
If it is the secretary, he may be a secretary.
Mhm.
If it is the call deposit at the behest of the society,
Lordship.
it means that this money had been paid into the bank for the call deposit by the society.
Yes,
So there is no doubt about the source of the money.
Lordship.
If it is by the society, the secretary,
Right.
there are two possibilities.
Hmm.
One, the money may be sourced from the society through the secretary to be deposited. Two, secretary may have gone to some stranger,
Lordship.
procured the money on his behalf
Lordship.
and then deposited.
Lordship.
If it is the second,
Lordship.
perhaps the requirement of the notifications will not be satisfied.
Wasn't छोड़ दीजिए। Here, this judgment with
See,
regard to call deposit.
Suppose a money is required to be paid by the Guwahati High Court.
Yes,
If it is paid by the Guwahati High Court, means it is a money of the Guwahati High Court, paid by the Guwahati High Court.
if it is paid by
If
the
it is
registrar,
given
your
by the Registrar
registrar of the
General
Guwahati. It is like that,
as a person,
not as a person on behalf
but
of this.
the person is also the, okay, fine, as the, he writes a designation also, okay, I am ex-Registrar General, pays it. A further inquiry will be required,
Yes,
whether the Registrar General had paid the money, procuring it from the Guwahati High Court and giving it on behalf of the Guwahati High Court.
Hmm.
Or the Registrar General had procured the money from some other extraneous source and gave it to the one. So this is the difference of a Bakija certificate and that of a call deposit. Now please submit.
Lordship, this with regard to call deposit, I got only one judgment.
Which one?
That is Gajen Chaudhary.
That 284,
284, 2000,
paragraph number,
paragraph 9.
paragraph 9
9,
notice in
11.
writing.
Here the difference is different. It is with regard to form. Then para 10, your lordship, why it is required has been given. In para 11, It is just NCL. These three paragraphs have indicated. Actually, a little bit different, but purpose is same.
That is for earnest money.
That was earnest money and call deposit. There was a given earnest money.
Understand, but
It
it is
court
for,
says that-
and this is for.
Exactly. I just want to point out one thing.
This is for what purpose? This call deposit?
Call deposit is basically earnest money.
No, earnest money or after
Earnest, it is
earnest money.
It is
Okay,
earnest
fine.
money. So that is why I'm saying, your lordship, this is why the para 10, the court has specified why the money is required.
The earnestness.
Yeah.
Earnest money follows from the word earnestness. How earnest you are to participate.
If
That
if I don't,
sincerity.
if I don't
Mhm.
follow it, then my money goes.
Yes, we are ready.
Then para 10, your lordship,
Para attended.
and 11, you.
Here it is, ultimate ratio is the would not have been put to any disadvantageous position had the earnest money furnished by the petitioner who was the highest bidder in the form of bank draft, etc., had been accepted. This is the ratio basically.
Yes, that
Yes. Para 11.
So the call deposit, your lordship, is basically the earnest money, which is required by the fishery department. So the main objective has been achieved by that deposit. The
Okay.
objective is achieved.
Fine.
by the settlement of the
Any
check.
more? Any more? Next one.
So that is with call deposit, your lordship. Then the,
Audited account.
then your lordship, I have.
Your next rejection is audited account that 2017-18 audit report was not
Audited-
given.
That part, your lordship, what has happened? Subsequently, it was at that point of time when it was submitted. We have made in the application itself, it was stated that it is under audit.
But yesterday, one application was shown by Mr. Bora.
Yes,
The application did not contain an averment that in the meantime, I got my 2017-18 audit report, please accept it. That statement is not there. The application is only that give me settlement. This is what Mr. Bora submitted.
that a heavy to nothing.
And he's shown the copy of the application also.
So
Okay,
that part, otherwise, your lordship, it was at that point of time under application, but it was not received.
And-
Subsequently,
no,
we have received it.
had you actually offered that in the meantime got it, please accept it. We'll take a view straight in your favor, no difficulty.
That, your lordship, again, I will go to the one more judgment, your lordship. Where it, your lordship, the.
If you had at any stage made any endeavor that yes, in the meantime, I got my 17-18 audit report, kindly have it, then we'll direct them to accept it. But as it is not there, let us not go into that any further.
Lordship, it was not there.
It was not there.
It was not
That's
there.
why I specifically asked Mr. Bora. If it is there, I would have gone in your favor.
It was not there.
Not there.
Subsequently, but the judgment has stated that subsequently we have
And what
covered-
judgment you wanted to rely on that?
the judgment, just a moment.
How it is relevant?
Just one moment. The third, basically with regard to the audit report, you know, so I have not specified, we got any judgment today. The only thing
If we
I,
have it, why don't you offer it to them?
we have it. You know.
Then why don't you give it to them?
We can give it. Your-
You were not given, that's a difficult.
That is true. I cannot say now.
Ah.
They should have
Had
given.
you given, that's why I
Yes.
said,
They should have given. it.
straight away.
Because in the
See,
single
you
bench
can
also they
take
said we
the
have.
words of the court, we'd have straight away gone in your favor.
Yes, they should have given it. But as per my instructions,
But if you're not given, how can we improve it? No.
because as per the record will reveal that it was not there.
Not
So
there.
I thought that it was given because from the order of the honorable single judge. it
But
came to
suppose it
effect
is
that
not,
somewhere it
suppose
was-
it is not given. Now what is your submission?
Lordship, my submission will be the same, your lordship, since that part will be curable because we have mentioned that we have already applied for the same, but we have not got
Mr.
at the time.
Mannan. A common cold, cold with a sneeze is curable. But you have to go and take the cure.
That is true, your lordship may be
So
true.
curable concept will come only when you have availed the facility of curing it.
Yes,
But if you have not availed the facility, it is immaterial whether something is curable or not.
in fact, your lordship, in the judgment that earlier I have given, where I have stated that even the court has directed in the other judgment where with regard to the neighborhood, court has directed that you produce a certificate now. That is while coming to the court after the settlement has been done. And the
Which
court
one?
directed,
Which
and
one?
your lordship also said that.
No, which one?
Hoop Gwal-
Whom?
Hoop Gwal- SCC online. It was in them.
Who,
Hoop Gwalpara. Yes.
where did it go?
Paragraph to move on there. Paragraph কোন পড়া?
Pub Golpara, yes. Paragraph?
খুব গল্প নয় খুব গল্প এখন তাহলে দিবি এখানে কি মই লেখা কোনো
Pub Golpara, you referred to para 14. We have marked it.
yes that মোৰখন ওলাই দিছিলো মই খুব গোৱালপাৰা Here, your lordship, in one paragraph, there is a
Yes.
specific direction that the
Which one?
authorities can make inquiries, 22 paragraph.
22.
If the authority has some issues with regard to my certificates, they can make.
The
a-
rank Vijayadara, another coordinate bench whatever held that it was incumbent responsibility to make such inquiry in order to reach a satisfaction, not only most deserving group is given, ensure that the interest of the government revenue is adequately protected. But what was the facts of that case? Raidora Burasora.
Yes, what I wanted to point out that if the,
No, it cannot
and
be.
secondly, we are the highest bid.
Mr. Manna.
Yes,
These things cannot be a non-ending running proceedings. So Raidora Burasora definitely said respondent to make inquiry.
yes.
How long will it continue?
No, they have fixed a
See,
time period.
today,
Yes.
you did not avail the opportunity when it was there. Come back to the court, and stated what? Whatever defect had been pointed out, rejected. I have a cover up for everything.
Mhm.
Now you want the court to again go back to the authorities' direction that consider those documents.
Yes,
Tomorrow, your document will consider, they will come and say, to overcome your document, I had another more document. Again, come to the court, then we'll also have to take the same view, allow him. Settlements will never be settled.
maybe your lordship.
It will be always in a fluid state.
Extent. But
So-
here, your lordship, what has happened? I'm trying to point out.
So after every defect is pointed out, after every proceeding is completed, then that too at a writ appellate stage. Now, somebody comes and says that, oh yes, whether I owed money or not, now you direct the government to make an inquiry on their own.
Government could have, yes.
Could have is another thing. Suppose we do it. The basic principle of bringing an end-to-end proceeding will be forever foreclosed and no proceeding can ever be brought to an end. if we pass that kind of a judgment.
This has been done in the other case.
So
Your Lordship.
that depends on the fact, what is the facts of that case, right?
Here, your lordship, they could have called us, produced the documents. They didn't.
Why? Why should they call you? Under where is that obligation?
No, that is why, your lordship,
So
it was an obligation.
the
on the highest
tenderer
bidder,
is
your lordship.
given
Normally,
all the due opportunity, and somebody finds something, somebody is not there. Go on giving opportunity. So if they give opportunity to you, will it not violate Article 14 vis-a-vis the other tenderers?
your
They'll first objection, they'll come and raise before the court and say that ex-tenderer had been given this undue benefit of bringing in more documents, whereas we are not. These are competitive biddings. Competitive bidding is, it's open for all, bring everything, whatever you have, we will take a call.
lordship, your lordship may be correct.
Hmm.
I'm not arguing on that. I'm just saying that I'm being the highest bidder. Normally what happens, your lordship knows that the highest bidder is called for your negotiations. Normally it is. called.
Those are
So in
basically.
fact, they should have called us and then they could have pointed us that these are your defects, you can cure it. That's that. point.
Yes, Mr. Das,
And
do you have
one
to
more
add
point, your
anything to what you stated, submitted yesterday? Yes, please.
I want to give another judgment, your lordship. It was very fun. Assam Fisheries with them. Yes, sir. Already. 2021 to GST. This is with regard to, here your lordship, just.
Mr.
I'll just
Manna,
give
a request from our side, please hurry up.
I'll just.
Because we can't devote one whole day of a bench for one fishery.
Then your
and-
lordship, just I'll refer the.
Then refer it, and if it is relevant, please point out that this is
your
the
I'll just point
proposition
out.
I want to rely on.
Yes, here your lordship, it is said that highest bidder should be accepted without there being a viability explanation.
Very well. Please give it.
Yes. This is Assam Fishery versus Nihar Ranjan Hazarika. I'm just giving, then another judgment, your lordship.
Could be say. Sorry, we have not got it till now.
Yeah. 2021 GMT. এখনো দিই একেলগে গোটেইকেইটা কৈ দিবি কিন্তু এখন মোৰ তাত থাকক। I'm just
Assam
referring
Nihar
your
Ranjan. Yes, which paragraph you want to rely on?
Your lordship will kindly turn to paragraph 16. No, sorry, 10 and 16.
10 and 16. The learned
10 with regard to
discussing
my,
detail founded nothing or recordation technical.
here your lordship yesterday said that my bidder is very high.
Viability. In
Yes,
other
that
words,
is why
it's
I
a
pointed
viability.
it out. Very high. So this is point. Viability was never there in their tender. So
What did the court say? Paragraph
then your lordship 16.
16.
16. And then your lordship 18 is the final order. Settlement to be given to the highest bidder with a liberty of additional security. Highest bidder. Take one this one. দেখুন নাই দিয়ে না রায়ডা গুলশা রাখুন
An explanation should have been called for. Okay.
Then you will see the another one. Here paragraph 8, you will. Raidak Burachora.
That right of Burasora.
Raidak Burachora, paragraph 8.
That was referred in that one.
Yes.
Hmm. Fishery matters also, Mr. Mannan, what has happened? These are so contesting
Yes.
Every time we will get a judgment here and there, but every judgment is influenced by the facts of that case. But later on, what is sought to be done to make it a general application under all circumstances? Every time it may not be. Every fishery judgment you find for the facts of that case. Even this one you have relied on,
Lots.
that Nihar Ranjan. Nihar Ranjan, what had happened? There not accepted the highest given to some lower bidder.
Yes,
Highest bidder says that I see a potential in the fishery that it may have a bigger yield.
Right.
Then what you go, if the bidder has seen potential of the present to yield a higher amount of fish, then it is in the interest of the corporation. This is what it says. Then it says, if he was the highest bidder and his bid was not being accepted, explanation should have been called and reasons should have been given why he had quoted such a high rate. This is what the court says.
Yes.
Suppose you have quoted an exceptionally high rate this time. If they have doubt, they straight away cannot reject it, but they'll have to call an explanation for it. This is all it provided.
that is,
It never says that a reckless bidding of the highest bidder has to be invariably accepted.
but your
This is not the proposition. Yes, next one.
interpretation, your lordship, I'll just.
That's why I say,
I'm not taking time.
that's
This
why I
way-
said, in the facts of that case, this was said.
The
Where
last-
without
last-
explanation, without anything, in an arbitrary manner, the lower bidder was accepted instead of the highest
Highest
bidder. In that circumstance, the court says.
Exactly, your lordship.
But this interpretation cannot be now converted to interpretation that a reckless bid of a highest bidder should not be questioned by anybody.
Lordship, even I
That
have gone
will
through
be a
this
little
last
preposterous.
judgment and then I will not.
Sorry,
My learned friend. One more last judgment.
please give it.
That is-
Raidak, Raidak, what does it say? You relied on.
Raidak
was referred. in
Raidak,
one
your
of-
lordship, para 8.
In Gwalpara, it was referred, na, Raidak. Para 22,
Here, para 8,
make inquiries.
para 8, Raidak.
Para 8. There is no gainsay in settlement fishery must conform to the goodwill of which a road in the exchange company. To even then, not only the most deserving group is given, but also in the interest of the government revenue is adequate protect. Technical shortcoming that neighborhood distance certificate as well 5 villages did not accompany that. This is okay.
I'm just pointing. it out.
The distance, because the distance between the fisheries can never change. What it was earlier before the tender, what it was during the tender, what it will be after the tender will always remain the
Yeah.
same. So someone did not give that certificate. The court says the government could have made an inquiry, send a model somewhere and they tell us the distance. That's all. Yes, next one.
Last paragraph, last page, last judgment. Para
271,
8, your lordship.
271, paragraph
8.
8. There is no gainsaying. This is same one, Raidak only.
Okay, right, I'm going.
This is Raidak. The one you referred just now. There is no gainsaying in settlement fisheries. Same one.
That is all.
Yes, Mr. Das. In your case, it was rejected. One demand draft was in the name of Jairam. And your submission yesterday was, it doesn't matter from where money comes. All that is relevant is money should be made available.
Right.
How do you justify that submission?
Actually, my lord, this is bank draft, my lord.
Sorry,
That-
bank.
Bank draft, my lord.
Okay, bank, very well.
That is to be accepted because actually only the requirement is, my lord, I am to deposit.
Mr.
the-
Das,
My lord.
the question put is not why a bank draft should be accepted. Bank draft accepted, we all know, there is a judgment also.
Also, my
Bank draft made at the instance of Jairam Sharma.
lord.
That is the issue.
No, my lord, actually, ultimately, suppose this is money only security money, my lord. Yep, this security money is to be returned to the unsuccessful bidder, my lord. In that case, this money will definitely, the money will go to the society, my lord, because that money has been deposited on behalf of the society.
No.
That is the
Sorry.
indication from the
Sorry.
lender, my lord.
Suppose today X makes a bank draft,
My lord.
pledging it in favor of, say, A.
Right.
A does not accept it, returns that bank draft back, and X wants to encash it to have his money back. If X had given that bank draft on behalf of Y,
Hello.
the money will not go back to Y. The money will go back to X himself. Because bank will re-encash it, or bank will return the money only to the person who had given money to the bank. Suppose Mr. Das had paid money to the bank
Right.
for a bank draft in favor of Mr. Count. And that bank draft is not required anymore. It is returned back. Bank will not give the money back to Mr. Count because it was for his benefit. Bank will give the money back only to Mr. Das, who had given money to the bank. Bank cannot give it to Mr. Count.
Actually, to my understanding, my lord. actually,
That
my
is the
lord.
banking principles as we understand. Yes. Dr. Saraf will be knowing more about this transaction. Are we not correct, Dr. Saraf? Even if it was made for the benefit of another person, ultimately not used, it has to be returned back. It will not be given back to the person for whose benefit it was made. Only to the person who had paid to the bank. I think we are right on the banking principles.
No, after all, my lord, after all, this the security money was deposited, my lord, on behalf of the society, my lord. That was the condition as part of the under notice, my lord. But only, my lord, that was rejected that the money is deposited by Joyram.
The reason is money is deposited by one Joyram.
Joyram Sharma, my lord. That's only on that ground alone, my lord. My tender was rejected, my lord. Then, my lord. I put one. Then, my lord, the next I will come, I will place before your lordship, my lord. What happened in this case, my lord, this, as per the direction of the state government, my lord. Then next, I will, before that, my lord, I will go to the settlement order, my lord. Settlement order at page 217, my lord, the relevant portion, my lord. Input settlement order, my lord, page 218, my lord. But on
218 of which writ appeal?
my writ appeal, my lord, my writ appeal,
Number?
218, my lord.
218 to sound.
That at page 218, my lord,
218.
218.
Your case number also 218, page also 218.
But 218. That is the petitioner society, my lord, the appellant society, they are Osudala FSC, my lord. The
218,
ground,
yes,
my lord.
we are in 218.
My lord. The experience certificate issued by the DFDO, Bangladesh, is in the name of the secretary of the society and that does not cover all the members of the society in terms of the clause 4 KA of NIT, my lord. That actually, that certificate, my lord, that is a wrong interpretation, my lord, that certificate, my lord. This is the certificate, my lord, annex along with the tender, my lord, where it that is also in the record is available, my lord, in the government record, my lord.
Please read what it provides, or let us see.
Actual fisherman certificate.
Actual fisherman certificate, my lord.
Experience certificate.
No,
This
they say experience is in the name of the secretary of the
Secretary, my lord.
society and not of the society.
No, my lord, it is in the name of the society, my lord. I'm sorry, my lord. I couldn't
No, it's okay.
copy, my lord. Yeah, all the members are actual fishermen belonging to the scheduled caste community. That is, especially it has been mentioned in that certificate, my lord.
Yes,
All the
this one we
members,
accept it.
my lord. Then next, my lord, next ground is, my lord.
This one we are in with you.
My lord.
Okay, next.
Next ground, my lord, for rejection, all the number 3, my lord, all the other documents found in order in terms of NIT, my lord.
And-
Then 4, my lord.
Ah.
The society belongs to Bongaigaon, the district, and hence
Aha.
not eligible to participate in that program, my lord. That for this, I will take your lordship, my lord. To the inquiry report submitted by the Learned Deputy Commissioner to the government, my lord, in the
Yes.
fishery department.
Page number.
That will be, my lord, page 82, my lord. Page 82 of the writ appeal, my lord. There is an extra 2,
Page 82.
82. This inquiry was conducted by the three district by the office of the Deputy Commissioner of the 3 district, my lord.
Hmm.
The Dhubri, Goalpara, and Bongaigaon.
Hmm.
This is letter addressed to the Commissioner and Secretary to the Government of Assam, Fishery Department, my lord.
Hmm.
This is letter dated 10th of February 2006. With reference to the subject cited above, I have the honor to inform you that as per instruction of the government by letter under reference, the fishery under group number 1, Dhar Brahmaputra fishery was put in
No, you
auction.
don't read the whole line. Take us to the line regarding the district where it is
My lord,
located.
that at page 83, my lord.
83.
At page 83, Goalpara.
You say
Sir,
that the most of the areas of the fishery. That is this Goalpara district.
Goalpara, Bongaigaon, and the Dhubri. Bongaigaon with the, my lord, it's like longest area, my lord. 19.70 kilometer, my lord.
Of this fishery.
Sorry, Goalpara is a 44.
You
and,
don't understand. Point out that the fishery is a 60%.
Well.
Regarding, who is your client?
Kosudhola, my lord.
Kosudhola.
That is from
Where is the provision settled in favor of Kosudhola?
Yes.
Kosudhola for a period and so and so. As by saying that the areas of the fishery, area of the fishery, not of Kosudhola.
No, my lord, area of the fishery, my lord.
Fishery it is in,
It is flowing through 3 districts, my lord.
understand, but the settlement is made by
By Dhubri.
Dhubri,
My lord.
out of which 76% is in Goalpara district,
Goalpara district,
6% in Dhubri,
Dhubri.
and
17% in Bongaigaon.
so
district,
then this will be a case
Well.
for you to file a writ application
my lord.
that the settling authority ought to be Goalpara, not Dhubri. You can take that stand.
So
Mr. Das, your
Well,
client is welcome
no,
with
that-
a writ petition
even then, my
that
lord.
this fishery, as because 76% is in Goalpara district, it is the Goalpara administration who will make the settlement. You come with an application, you'll get it order.
Yes.
But your case was rejected, saying that the society belongs to Bongaigaon district
Bongaigaon
and
district.
not eligible to participate in
Participate in the tender process.
a tender of Dhubri district.
Dhubri, my lord.
This is the reason.
My lord.
What is your answer to that?
No. Not that, for that, I will take your lordship. These are before that, actually, this particular fishery in question, my lord, that was also settled with us, my lord. That your lordship will find at page 154, my lord.
150. Earlier it was settled.
It was settled. By settlement order dated 5th of April.
Yes, Mr. Bora, why did you settle it earlier? And now you don't settle? We'll hear him on that point. On page 154.
Now, these are the, by this.
And,
my lord, actually,
and any more point, means we have to come back and start the
oh,
order.
my lord.
Any other point?
That, my lord,
154 we have
for the
taken note of.
support of that, my lord, that there are one is passed by the line of single judge, my lord, and another is a division based, my lord.
Which one? On which point?
About this point, whether we can participate in the tender process, my lord,
Whether a tender from another district.
another district, my lord.
That judgment is there.
My lord, that
Let's
is.
see. If it is there, they cannot reject it. Poop Golpara, again that Poop Golpara.
Para number 25.
No, one Poop Golpara was given to us. That is different or same one?
Same one. But they have relied on a different paragraph. We are relying on paragraph.
Okay, but ultimately judgment is same.
No,
Judgment is
judgment
same.
is
Which paragraph?
25 and 27.
25 and 27.
Yes, single bench. Single bench, you know.
There's another judgment I am placing before your lordship. Single bench.
Is it this judgment passed by the Lord single judge that was confirmed by the division bench, my lord?
But in this tender notice,
Right.
what is the date of the tender notice?
In this case, madam.
In this
Notice dated
Date of the
18,
tender
12,
notice.
2018, my lord.
2018.
18.
Yes, Mr. Bora. Mr. R.K. Bora. I come to page 37 of Mr. Ken Chaudhary's appeal.
Yes. Before.
37 of Mr. Chaudhary.
Yes.
Clause number 2.
Yes.
100% অনুচিত জাতি বা বৰাক so and so আৰু মীনমহল পালকে নিবিদা দিব পাৰিব। নিবিদাকাৰী সংশ্লিষ্ট জিলা আৰু মীনমহলখনৰ ওচৰ চুবুৰীয়া হ'ব লাগিব। সংশ্লিষ্ট জিলা had been overruled by the division bench in the judgment just now shown.
Yes, Poop Golpara.
And this overruling is later. And means this kind of a clause in a tender notice had been rejected by the division bench. Division bench gives the reason that one of the criteria is neighborhood, which is also here. Min Moholor Usor Suburia Hobo Lagibo. So by invoking the clause of Usor Suburia, if you are a fishery of the neighborhood, Usor Suburia, irrespective of the difference in the district, you can still participate. So we reject this ground. Reject the ground of rejection of Mr. Das on this ground. Rest we'll examine. We'll come back in the deliberative order.
A short reply of 2 minutes, madam.
Enough. Because the points you have raised, I don't think any reply.
One minute reply.
Then
Yes,
you
yes,
can
yes.
put in some other date. You go. Minus the interim order. We'll give you 1 month's time, no difficulty, but minus the interim order. See, fisheries, it's highly contesting, we know. But what public importance it has? It's only between two groups who is fighting with each other, like anything. Otherwise, there is no public interest at all. Is anybody of the society ever bothered about to whom one's fishery goes? No one. How can we devote more than one whole day? Yesterday's half day and today almost for one matter. You will just go on arguing with each other. It has to come to an end. The court time is precious. We have to attend to so many other matters. So just between one fishery, who will get it? For that, how can you go on spending days after days? Does it have any public interest otherwise, other than the interest of two private contesting parties? Nothing.
Lordship closing.
But when there is a requirement to decide a question of law, maybe we'll hear a little longer, because that will have its implication on later settlements also.
If the point of this district is goes, then
You have made your point very clear yesterday. And what do you want to say more?
Just only as regards rule 48,
Rule 48.
of the fishery rule.
What
We
is
say
that?
that it has to be determined as per the area of the land, area of the fishery.
Huh.
So it cannot be exorbitant rate because the government rate is fixed at 2,28,000. They had quoted 3 crores.
Such on to Mr. Mannan's that
Yes,
exorbitant.
yes, madam. Because as per rule 48,
But
yes.
that issue is not here before this.
because once they had raised that, we had raised 3 crores and one has raised 1 crore.
This is, that issue is not a determining factor for this litigation. In appropriate case, you list it where the only issue is rate. Here,
The-
your issues are something
And the
different.
other issue is, madam, in Pumkwalpara case, madam, that gazette notification was not an issue at that case. madam. That is the only.
We intend to finish by half an hour. No, the judgment.
Okay. I don't think any reply is required, my
I
lord.
don't think it is required. Only one point regarding the district.
Yes.
Mr. Das relies on a later writ appeal judgment, which says that if it is otherwise in
Access
the
to 2, 3
the
districts.
neighborhood,
Yes.
it is permissible.
But my lord, then that
But
condition
that-
is not challenged.
But, sorry,
That condition in the NIT is not.
no,
under
no, that's
challenge.
why I asked. NIT is prior to the writ appeal judgment.
Today, actually,
And NIT is prior to the, that's what I asked him.
There is a fair in my intuition, my lord, for bifurcating the fishery, my lord. That is always there.
Oh, bifurcating is a different. No, my lord, leave it to Lord.
I heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Buddhi Jiwaha, for the appellant in WA 186/2023. Mr. N.C. Das, Learned Senior Counsel in WA 218/2023. Mr. Mannan, does he have any appeal of his own? No. Why 3 appeals are there?
They have.
They have,
Mhm.
they have not.
We have 2 appeal.
To
We have 2 appeal.
by, Acha. You have filed 2 appeals. Okay. fine. Mr. Kenji, Senior Counsel in WA 186 and WA 216. Mr. NC Tawar. Also heard Mr. Y.S. Mannan, Learned Counsel for the respondent. Respondent MS Dheer Beal Fishermen Cooperative Society Limited. Appellant in Harry, namely MS. Dharnad Brahmaputra Fishery Cooperative Society Limited. Haru Ehri 218 appellant. E2 Fishery Kosudhola down NC Das. এনেকুৱা আছিল আৰু YS Manna for the respondent MS Dhir beneficiary তেতিয়াহ'লে কোনটোত কি আছে আৰু বেলেগে ডিটেইল নালাগে দিব as well as Mr. R.K. Bora, learned additional senior advocate for the respondents through the
1, 2, 3, 4.
in the fishery department as well as the deputy commissioner Dhubri. A notice inviting tender dated 17/12/2018 was issued by the deputy commissioner Dhubri inviting tendered bids, comma, for settlement of, comma, amongst others, comma, what is the name of the fishery?
Group number 1, Dhar.
Sorry, name of the fishery.
Group number 1, Dhar Brahmaputra fishery.
It লিখি ল'ব। अच्छा हाँ ग्रुप नंबर 1 धौर ब्रह्मपुत्र फिशरी some of the relevant terms and condition of the tender notice are as extracted. দিব ক্লজ 2 দি দিব cooperative societies comprising of 100% scheduled caste fishermen, a fishermen belonging to the scheduled caste, or the Maimal community of Barak Valley shall be eligible to participate in the bidding process. Is my translation right? Mr. Chaudhary, is my translation right? Is my translation right? For idiotson. Actual fishermen. Scheduled caste community or Maimal community of Barak Valley shall be eligible to participate in the bidding process. Full stop. The bidders shall be from the district concerns and fisheries located in the neighborhood of the fishery. Eight kho to দিব, and 8 kho na 4 kho. A Bagija certificate with proof of no dues from the deputy commissioner, bracket, The certificate should be from the appropriate official in the office of the Deputy Commissioner, clearly stating the name of the society or the group. Check the translations because we should.
I think self-help group, my lord,
No,
society
no,
NGO
no,
self-help.
for a committee ba gotor naam.
It's a good.
Nothing else is written there. Committee ba gotor
Actually,
naam.
they are referring to NGO or my lord, self-help.
No, what?
Okay.
I am going by the what
Yes,
is
yes, yes,
provided.
yes. If we read it together with rule 12 proviso, my lord, then
No, I'm
it's
writing
okay.
only.
Only translation
not,
part.
interpreting.
Yes, yes.
Ungo. Sari ungo. Amanat Dhon means security money.
Security.
Security money amounting to 15% of the minimum government value of the fishery shall be deposited in the form of call deposit clearly stating it to be in favor of the Deputy Commissioner stroke subdivisional officer in the name of the Deputy Commissioner stroke subdivision officer, along with no, along with stating the name of the cooperative society stroke Atma Hohaya self-help group shall be deposited. Rest are not required. I think jaw will be required. Jaw. Balance sheet of the audited balance sheet of 3 years from the current year of the cooperative society stroke group shall be required to be submitted. Bracket. The balance sheet should be authorized by the no, should be approved by the authorized official. I think that is good.
Yes.
I think these are the 4 clauses. The
Basically.
rest are not required. Full stop. It has been given to be understood that supplementing the provisions in the tender notice itself, the government of Assam in the Fisheries Department had also issued a notification dated 18/1/2018 bearing number, it page 42 to say, huh? Fish bearing number fish so and so, wherein it is provided comma, amongst others, comma, as extracted. Ek number to documents to be submitted to DCSDO bracket C along with tender documents. Roman 1 eta ase. Of this one, to 3 to dibo, fisherman cooperative, 4 baki jai, 5 security deposit, and 9 balance sheet. Rest are not required. In the bidding process, the respondent MS Jeer Beal Fishermen Cooperative Society Limited had submitted a tendered bid amounting to rupees. Give a figure. Give the figures, please.
Yes, yes.
The figure to the 3 crores something for 7 years or for per year.
7 years.
For 7 years. For 7 years. Whereas the writ appellant MS Kosudhola submitted a bid of Iman Aru and the writ appellant MS Dharnar Brahmaputra Fishery Cooperative Society submitted a bid value of rupees 1. By the order dated 24/3/2022 of the Joint Secretary to the Government of Assam and the Fisheries Department, the settlement had been made in favor of number 1 Dhar Brahmaputra Fishery. Pura naam to did one, Dhar Brahmaputra Fishery Cooperative Society Limited negi. At their tendered value of rupees 1,22,50,000 for 7 years. The order dated 24/3/2022 of the Joint Secretary itself contains the reason as to why the bids of the other bidders were rejected and the bid of MS Dhar Brahmaputra accepted. The reasons provided in the order of 24/3/2022 in respect of the respondent MS Dheer Beal FCS Limited is as extracted. 63 আছে হ্যাঁ 1 নম্বর ধরতো গোটেইটো উঠাই দিবা The reasons in the order dated 24/3/2022 for rejecting the bid of the writ appellant MS Kosudola FCS Limited of Vayapuri is again as extracted. For accepting the bid of MS Dharnar Brahmaputra FCS Limited, the reasons provided in the order dated 24/3/2022 is again as extracted. Full stop. MS Dheer Beal FCS Limited instituted WPC double 450
Of 22.
2022, assailing the order of settlement dated 24/3/2022, whereas MS Kosudola Fishery Cooperative Society একটু শর্ট করে যেনেকে লেখা এটা লিখি দেবা হ্যাঁ কসুরগুলো instituted WBC 3736/2022 assailing the same order. By the judgment and order dated 22/5/2023, comma, the order of settlement dated 24/3/2022 made in favor of the appellant MS Thor Brahmaputra was interfered and set aside. Being aggrieved, this writ appeal 186/2023 had been instituted by the appellant Thor Brahmaputra against the judgment and order passed in respect of WBC 4450/2022 and writ appeal 216, I think that 216 had been instituted against the same judgment and order dated so and so in WBC 3736/2022. On the other hand, the appellant Kosudola Fishery Cooperative Society Limited had also assailed the judgment and order dated so and so, the common judgment order dated so and so in the two writ petitions on a limited ground that by the said judgment it had been held in favor of the responded MSA Dheer Bill Fishermen Cooperative Society Limited. In writ appeal 186/2023, the core contention raised is that while dealing with the reasoning of the settling authority in the order of settlement dated 24/3/2022, as regards the Bakijai certificate submitted by the respondent MS Dheer Bill FCS Limited, the learned single judge in its conclusion as in its judgment dated so and so had firstly interfered, comma, as provided in paragraph 12 of the judgment, comma, that the notification dated 18/1/2018, which had also been relied upon by the settling authority to arrive at a conclusion in respect of the Bakijai certificate of MS Dheer. Comma, by relying upon a judgment of the Supreme Court rendered in G.J. Fernandez versus State of Mysore, reported in AIR 1967 SC 1753, comma, would be unacceptable. Full stop. The other ground in writ appeal 186/2022, as regards the rejection of the call deposit of MS Dheer Fishery, that it was issued by an individual. It was issued in the individual name of the secretary and not the society itself, as required under clause 4 of the NIT, comma, as held by the learned single judge in the judgment dated so and so in paragraph 37, that it is merely a trivial ground which cannot have any impact on the decision-making process. By following a proposition laid down in MS Goripur Cooperative Fishery Limited, it would detail to the reported into Alapan Bisot signing, would also be unacceptable in law, that the said defect is the said defect cannot be a curable defect. And further, the call deposit being issued to be the requirement of the call deposit to be issued in the name of the society itself has its own purpose, which cannot be achieved if issued in the name of the secretary of the society. As regards the reasoning of the settling authority regarding non-furnishing the audited accounts by the MS Dheer, where the tenderer had submitted the audited account for the years 2012-13, 2015-16 and 2016-17 instead of the preceding 3 years, that is 2015-16, 2016-17 and 2017-18. Where was it dealt with by the learned single judge?
Yes.
This
Page 237, madam.
237.
No. Right? Balance it. Page 237, para 37, later part, my lord. Fourth sentence. Regarding audited balance sheet.
Comma, people, last sentence. Comma. The conclusion of the learned single judge in paragraph 37 that the explanation that has been given that for the year 2017, although the audit report was not submitted at the time of submission of the bids, but it was subsequently submitted, is also factually erroneous. And therefore, the reasoning of the settling authority to reject the bid of MS Dheer Fishery for the reason of not having submitted the audited reports in the required manner was a right reasoning for rejection of the tendered bid. Where is the experience certificate of Kosudhola dealt by the single judge?
Page 216, my lord.
216. No, conclusion.
Regarding my lord.
Kosudhola experience certificate.
Yes, once.
Because difficulty is this a common judgment?
238.
238.
Para 40.
40.
Para 40, my lord. On top. Jairam Das no
Full stop. The reasoning of the settling authority in the order dated 24/3/2022 that the experience certificate issued by the DFDO Bongaigaon is in the name of the secretary of the society and therefore does not cover all the members of the society had been dealt with by the learned single judge in paragraph 40 of its judgment, wherein a conclusion was arrived at. Thus, said reasoning is expressly erroneous as the experience certificate indeed did contain although in the name of the society, but indeed it covered all the members, which according to the appellant is an incorrect conclusion of the learned single judge. With regard to the reasoning regarding the bank draft submitted as security deposit was purchased by another person, namely Jairam
It should be Sharma.
Sharma, bracket SIC Jairam Das Sharma, who is not an authorized person, comma. Where was it dealt with?
That same, my lord. Page 238. So far as
The conclusion arrived at by the learned single judge
as regards
that the same is not a relevant issue, and even if it is held to be a defect, the same would be a curable one, is also erroneous, in as much as, according to the appellant, the purpose and purport of a security deposit is that it is the bidder who makes the bid, makes the security deposit, and it is not done on behalf of somebody else, or not done by somebody else. As regards the reasoning of the settling authority in the order dated 24/3/2022, that the bidder MS Kosudhola FCS belongs to the Bongaigaon district, whereas the settlement is being initiated by the Dhubri district, and therefore they are not eligible to participate in the tender process as per clause 2 of the NIT, comma, the learned single judge, where is it dealt? Is it dealt anywhere?
that aspect is not.
Had not even been gone into by the learned single judge in the judgment impute. Whereas on the other hand, according to the appellant, the said reasoning is a valid reason to reject the tender process in as much as it violates express condition of the NIT itself. Mr. Ken Chaudhary, learned senior counsel for the appellants in WA Iman and Iman. No, also assails the judgment dated impute judgment so and so of the learned single judge. As regards the view taken that the notification dated dated 18/1/2018 is not a law passed by the legislature of the state, but an executive instruction. And therefore, such notification shall not be enforceable in law is also an incorrect conclusion, is also a conclusion which is incorrect in the circumstance of the present case. Incorrect and irrelevant for the purpose of the present case. That was yours.
Okay.
We'll continue. I think it will take some time.
Second about elect dance. Elect dance.
On the issue that the Bakijay certificate of MS Dheer bill, it was short kori thoi diba niki agote nahole every time we are repeating of MS initially, right, and go on repeating that of MS কি করবো issued a certificate of MS Dheer bill was more than 90 days old at the time of consideration of the tendered bids and therefore not valid, comma. Mr. Ken Chaudhary learns in a counsel for the appellant. What was the name? Dharnad, no? Of the appellant. Dharnad Brahmapura Fishery. Refers to the clause 8 core of the NIT, which contains the requirement that the bidder would have to submit the Bakijay free certificate from the Deputy Commissioner, which may be issued by any appropriate official in the office of the Deputy Commissioner. And submits that the Bakija certificates are ordinarily issued with a prescribed duration for which it would remain valid, which itself is an indication that the period for which such certificate is issued is also a relevant consideration. In the certificate issued in respect of the respondent Dhirbil FCS, the certificate that was issued did not contain any period for which it was issued. And it merely provides that there is no Bakija case that has been instituted against the president of MS Dhirbil Fishermen FCS, of Dhirbil FCS. And that the said certificate is dated 26/6/2018. Mr. Ken Chaudhary and Senior Counsel also refers to clause 4 of the notification dated 18/1/2018, which provides that the Bakijai clearance certificate is to be furnished by the Bakijai authority under the concerned Deputy Commissioner, where the society or the NGO is registered, and should invariably be in the name of the society, NGO, or SHH, as the case may be, and not in the name of the office bearer of the society. Mr. Y.S. Mannan led counsel for the respondent Dhirbil FCS, on the other hand, by referring to clause 4 core of the NIT and clause 4 of the notification dated 18/1/2018, submits that the said provisions do not anywhere indicate that the Bakijai certificate should not be prior to 90 days of the date of consideration of the tender. Mr. Mannan, on the other hand, by referring to the reasoning provided by the settling authority in an order of 24/3/2022, submits that even the said reasoning that under the provisions of the ARTPS Act 2012, the validity of such certificate is for 90 days from the date of issue, is also untenable. Inasmuch as the ARTPS Act 2012 does not contain any such provision which requires that the certificate should not be should be within 90 days, that the validity of the certificate should be for 90 days from the date of the issue. To substantiate his submission, Mr. Y.S. Mannan also refers to the judgment rendered by the division bench in You've given a different copy. No, no, that one, Pub Golfer. Mhm. Fourteen. Where did my money go? This one I marked something here. Well, assets was. This one. কি বলো? In Pub Gwalpara Fishery Cooperative Society, represented by Secretary Sri Ranjit Kumar Das versus State of Assam. Represented versus State of Assam and others, reported in 2022 SCC online GAU 731. কি বলো line to, please? Sentence কি বলো? Refers to the heading. Wherein in paragraph 14, the rejection of a Bakijai certificate by the settling authority on the ground that the same was issued by an authority other than the deputy commissioner was rejected by the division bench, where further it was provided that it was open for the official respondents to make necessary inquiries to find out if there are any dues payable to the government by the tenderer concerned. And therefore, it was an aberration in form and not in respect of the content of the certificate. Accordingly, by relying on the same proposition, it is submitted that in the instant case also, the settling authorities could have made an inquiry as regards the Bakijai, as regard the debt dues of the Bakijai dues of the society, rather than rejecting the Bakijai certificate merely on the ground that it was more than 90 days from the that it was more than 90 days from the date of consideration. Further reference is made to the judgment of the court rendered in yesterday. Abu Talib by judgment of the division bench in Abu Talib to Abu Talib versus Assam Fishery Development Corporation reported in, is it reported or no?
No.
They delivered it by the order dated 29/9/2011 in WA 294/2011, wherein it had been provided that the requirement of submitting a Bakijai clearance certificate cannot be taken as a rigid requirement. And hence, rejecting the Bakijai certificate of MS Dhir bill on the ground that it was more than 90 days old from the date of consideration was incorrect. Did you refer any more or these three?
These two with regard
These
to
two
Bakijai.
mainly. Others
And
are,
one, your lordship single bench judgment was there with regard to Bakijai part.
the name of the parties. Is it Assam Fishery Nihar Ranjan? Gauripur. এই কোটাকে একটা bunch করে দিই আমরা। Make one bunch of them. Spread all over.
That is Gauripur, your lordship. Gauripur Cooperative Fisheries Society.
মূর্তিটা চিন্তা করে দিয়ে একটা bunch করে দিয়ে বলে কোন হয়। Paragraph 7.
7.
Reference is also made to the pronouncement of this court in MS Gauripur Cooperative Fisheries Society Limited versus State of Assam and others. This is also not reported. This is also not reported.
Gauripur may not be, no, not yet, madam.
Hmm.
It's a very recent order.
No, Gauripur is 2022.
Gauripur
Hmm.
is
Uh,
11/11/2020.
Wherein by the judgment dated 11/11/2022 in WPC 6885/2022 in paragraph 7. It was held that an incorrect certificate which was submitted earlier is a curable defect which is an acceptable proposition of law in a tender process. Accordingly, a submission is made that in the instant case also, the Bakijai certificate of MS Dhir bill being more than 90 days old from the date of consideration is also a curable defect. Stop. The relevance of a Bakijai certificate for a tendering process is that the bidder concerned does not have any dues payable to the government authorities from any prior proceeding. This view had also been accepted by the division bench in paragraph 14 of its judgment rendered in Poop Gwalpara Fishery Cooperative Society Suprad, wherein it had been provided that a Bakijai clearance certificate is required to ensure that there are no dues payable by an applicant bidder in respect of any revenue to the government. And in short, the Bakijai clearance certificate can be termed to be a one inverted comma, no dues certificate issued by the competent authorities. Stop. If a Bakijai certificate is for the purpose of ensuring that there are no dues payable by the bidder to the government authorities. Not now. You cannot.
I'm not making.
Please, we get disturbed if you just. Mr. Manan, at the end of the order, you can
Yes.
point out something, but please not in the message. Comma. The reasoning adopted by the settling authorities that the Bakijai certificate of MS Dhirbir is more than 90 days old from the date of consideration cannot be said to be either arbitrary or unreasonable or illogical in any manner. An old certificate can depict that the bidder has no dues to the government for a period, for any period prior to the period immediately preceding the date of consideration of the tender, which does not give the answer as to whether for the period immediately preceding the date of consideration, whether there is any Bakijai dues by the bidder or not. What had been provided in paragraph 14 of the judgment in Pub Gwalpara was in the context that in the said matter, the Bakijai certificate was issued by an authority which was other than the deputy commissioner. But otherwise, the certificate was a valid certificate as regards the period for which the certificate was issued. In the said context, the division bench provided that if the contents of the certificate is otherwise correct, but the aberration was that it was issued by an authority other than the deputy commissioner, when actually it was the deputy commissioner who ought to have issued the certificate, comma, the same is an defect in form and not in respect of the content. In the instant case, it is noticed that when the requirement of submitting a Bakijai certificate has not been achieved, inasmuch as it is not certified as to whether for the period immediately preceding the date of consideration, any dues were there to be paid by the bidder, comma, it have to be understood that the said defect would be more of a defect in content rather than a defect in form. From such point of view, the reasoning adopted by the settling authority in the order dated by the settling authority in the sorry, in 24/3 in the order dated 24/3/2018 cannot be 24/3/2022 cannot be said to be either arbitrary or unreasonable or illogical or not relevant for the in the context of the settlement. The reliance placed upon by the learned single judge upon the proposition laid down in Abu Talib Supra that the requirement of submitting a Bakijai clearance certificate could not be taken as a rigid requirement and neither it was a case where level playing field was denied or a case had been lost or a case where loss had been caused to the public relevance. কি করলো? Comma would have to be understood in the context of the factual matrix of the said matter where this observation was made. In the matter before the division bench in Abu Talib Supra, comma, the bidder therein had not submitted the Bakida certificate along with the tendered bid, but was subsequently allowed by the settling authority to submit the Bakida certificate, which was accepted. And a challenge was put forth that the act of the settling authority in allowing the Bakida certificate to be submitted subsequently was erroneous. In the said submission, in the said context, it was the submission of the bidder who was allowed to submit the Bakida certificate that the non-submission, that the initial non-submission of the Bakida certificate was a curable defect. And it is in that context that the observation was made that submission of Bakida certificate could not be taken as a rigid requirement. The concept of curable defect is an acceptable proposition in the law of tendering process. A document that may be required to be submitted in a tendering process may be of two types. The first type being the document itself creates the existence of a fact, where the second type would be that the document depicts the existence of a fact which is already existing. If the relevant document itself creates the existence of a fact, and such document was not produced along with not produced while submitting the bids, a later submission of such document cannot be held to be a curable defect, inasmuch as at the time of non-submission of the document, the required fact did not exist, and it was made to exist only when subsequently the document was procured and submitted. But on the other hand, if the required document is of the second type, that it merely depicts the existence of a fact which is already existing, comma, a non-submission of the document at the time of submitting the document will not render the fact which existed to be a non-existent fact. In such circumstance, when the document is procured subsequently and submitted subsequently, will still depict the same fact which even earlier existed. Such documents which depicts an existing fact and does not create the existence of a fact if not submitted at the time of submission of the bill of the bids, but had been allowed to be submitted at a later point of time, would have to be construed to be a curable defect. From such point of view, we will have to agree with the submission of Mr. Y.S. Mannan, Land Counsel for MS Dhirubhil, that in the instant case also, the non-submission of the Bakijai certificate being a curable defect, the authorities could have granted the said bidder an opportunity to submit a more correct version of the Bakijai certificate. But for the purpose, we have noticed that the records reveal that there was no such request by MS Dhirubhil to allow them to submit a more corrected version of the Bakijai certificate when it was noticed that the earlier certificate did not serve the purpose for which it was submitted. For the purpose, we even verified the records, and from the records, there appears one application by MS Dhirubhil. But the said application also does not contain any request to the authorities to allow them to submit a more corrected version of the Bakijai certificate. A curable defect can be allowed to be cured only when it can be allowed to be cured when it is sought to be cured. But when the bidder do not sought the defect to be cured, we see no inherent responsibility being bestowed on the settling authorities to go out of turn and on their own point it out to the bidder, give him the opportunity to submit a more corrected certificate and take that into consideration. In fact, if that is done, it would be adoption of a discriminatory procedure in favor of one of the bidders, which may again entail a possible violation of Article 14 of the Constitution. From such point of view, we are unable to accept the submission of Mr. Y.S. Mannan that as the Bakijai certificate itself is, non-submission itself is a curable defect. Therefore, the settling authority ought to have given an opportunity to the respondent MS Dhirubhil. As regards the provision of the division bench in Abu Talib Supra, that the requirement of submitting the Bakijai claim certificate could not be taken as a rigid requirement, comma. It is noticed that the said observation was made when it was not an issue before the court as to whether the Bakijai certificate, requirement of submitting a Bakijai certificate is a rigid requirement or not. As already indicated above, the core issue in the matter in Abu Talib was whether allowing the bidder to submit a Bakijai certificate at a later point of time after submission of the bid was arbitrary or not, where the stand taken was that it was a curable defect. As it was not an issue before the court, such observation would have to be understood to be an obiter dicta rather than a ratio decidendi to make it binding. If the purpose of a Bakijai certificate is to ensure that that is a certificate of no dues to the government, as indicated in para 14 of the judgment of the division bench in Pub Gwalpara, comma, where the requirement of a bidder being free of any debt of any dues to the government is a requirement, comma, we have to understand that the Bakija requirement of a Bakija certificate would also be an essential requirement in a tendering process. Full stop. Accordingly, Abu Talib, the provision of Abu Talib regarding the requirement of Bakija certificate being not a rigid requirement is clarified accordingly. On the issue of the call deposit in respect of MS Bill FCS being issued in the name of being issued in the individual name of the secretary of the society, comma, Mr. Ken Chaudhary and Senior Counsel for the appellant Dharnad of the app. His names are also very difficult to remember. Dharnad Brahmaputra. Had referred to clause 4 unga of the NIT, wherein it is specifically provided that that 15% of the minimum value of the minimum government value of the fishery would have to be deposited in the form of a call deposit, wherein it should be specifically, where it should be clearly stated that it is in favor of the deputy commissioner or the subdivisional officer, as the case may be, by mentioning the name of the cooperative society or the self-help group whom may submit such call deposit before the authorities. Start what and therefore, as there is a specific provision that the certificate should mention that it is the cooperative society or the self-help group who had submitted the same. Line to misspell the line. Oh, yes, you know. No, sentence to body. Submits that. In the instant case, as the call deposit had been submitted, had been issued, the call was submitted in the name of the secretary of the society. Therefore, there is an aberration of clause 4 core, and as such, the said call deposit had been rightly rejected by the settling authority. What is your submission, Mr. Mandan, on this call deposit? What did you say? Just in one line, so that we can recollect. Don't make the entire submission. Just the indication what was your call submission.
The call deposit, in fact, your lordship, was submitted by the secretary on behalf of the.
So they rejected it.
It is not.
How do you justify it?
And I justified by saying that his by the, it is not by some other person. It is
But by the, no, you referred one judgment if I.
Yeah, judgment I referred, you.
Which
Just
one? W. W 284.
That was your lordship in 284/2011, Gozen Chodhary.
That it is merely an ancillary and
Yes, paragraph,
merely ancillary and
paragraph
subsidiary
9,
and not a main requirement. কি করো, Mr. Change করবেন কি? Mr. Y.S. Mannan led counsel for the respondent MS Dheerbil Fishery Cooperative Society, FCS, on the other hand, by referring to the proposition laid down in paragraph 10 and 11 of the judgment of the division court rendered in Gozen Chodhary versus State of Assam and others in WA 284/2011, wherein in the order dated, order dated so it had been provided that as the form of the bank draft upon being accepted could have been encashable and deposited in the corporation's account, comma. Therefore, it was in paragraph 11, it was construed that such conditions stipulated in the NIT that it has to be that the name of the society or the several group should be specifically mentioned is merely an ancillary or subsidiary requirement. Stop. Call deposits, the requirement of submitting call deposits as per clause 4 is that the bidder who submits the form, the call deposits, sorry, is for the purpose of submitting the earnest money by a bidder while participating in the tender process. The purpose of earnest money is to ensure that the bidder shows some earnestness in submitting the tender, and he has earnestness and seriousness in submitting the tender, meaning thereby that it is the bidder who has to deposit such amount with the tendering, with the bidding authority, with the tendering authorities. True, it can be said that if the call deposit had been made in the name of the secretary of the society, it cannot be wholly rejected because the secretary himself is a part of the society, and therefore it has to be understood that the deposit was made on behalf of the society itself. The said aspect would also require a further consideration. If the call deposit had been made in the name of the secretary of the society. The settling authorities can always require the secretary to produce relevant materials materials to show as to what was the source of the money that was used for making the call deposit. If the source of the money can be sourced to the society itself, it cannot be said that a call deposit made in the name of the society would be unacceptable. But on the other hand, if the secretary is unable to show that the source of money is from the society itself, it would again mean that the money in the call deposit is from some other source and not the bidder, which again will not show any earnestness or seriousness on the part of the bidder to submit the earnest money. Such further, we leave it to the settling authorities in future to deal with such matters as it may arise. But in the instant case, as there is no such material, that the source of the money in the instant case resulting in the call deposit in the name of the secretary of MS Hirbir is not being sourced from the society itself. We are of the view that a mere rejection by the settling authority without any further inquiry that it was in the name of the society and in the name of the secretary, not the society, would be unacceptable, where it had already been provided by the division bench in WS so and so that such conditions are more of ancillary in nature, ancillary or subsidiary in nature. As regards the, what do we do? I think it will take some time. We'll have to go, three issues are, no, three each are raised. We'll have to answer all three together, one by one. We cannot.
Financial part is there.
See, first complication is it's a three-way direction, and there's a common judgment. In the common judgment, you have raised three issues. Mr. Kosudala has raised another three issues. And we have to answer issue wise. Otherwise, what else do we do? We'll discuss tomorrow again. We'll continue with that.
Lordship will only dictate the response.
Sorry, only for the order purpose. Possibly in the second half, we'll make an attempt to finish it off. List again on tomorrow. Written for it. Okay. All other matters, some date will be given. Oh, some other day. All the matters. There's hardly
5 minutes.
because the other bench is already notified for 3 o'clock.
Otherwise, my lord, the constitution bench
But-
judgment covers that.
Sorry. No, we fix one particular day, all the matters will be listed on that day.
There's hardly any time.
25th July. 25th July. Or any urgency in any of the matters. No? Your urgency will be only next year, I think.
Mine in that case, the double taking.
That one may require some early hearing. No? Or it can wait. That somebody made some double marking in the answer script. That
Yes, yes. Ultimately, an inquiry report has come. We have served the copy. The inquiry report copy we have served. The petitioner possibly will make some submission.
Mr. Talukdar, just a minute. I think a subsequent Supreme Court judgment has come
Yes, I
After the
gone
legal.
through it, my lord.
Now what will be the
It may
effect?
not be very helpful to them.
Sorry,
It may not be very helpful to the petition,
it may not be helpful.
subject to what my,
Okay, we'll hear what.
I'll place.
But the earlier judgment you were relying in, I think the later one has taken a little different view.
Yes, Lord.
Because those, some acts were enacted by the three states, my lord. Karnataka, Tamil Nadu and Maharashtra. Those
I-
constitutionality of those three acts were challenged before the
Hmm.
Supreme Court and those.
And
were
those acts
provided
provided for this one,
Provided.
and their constituency was challenged. And the Supreme Court upheld
Upheld
the,
the constitution.
upheld the constitution.
But there is no such provision in state of Assam.
Okay, you are looking from that point of view.
Right.
If the state of Assam creates a statute, you can do
Then
it.
they can do it.
But as long as we don't create a statute, the earlier that para
That
42, what,
vigor of.
then that will
Nagaraja
remain. Okay, interesting.
Right.
We'll hear you.
But my lord, the impugned order had recorded that in view of this Supreme Court judgment banning Jallikattu, we are also banning this,
Sorry,
that-
buffalo fight. That was the reason given in the WT message, impugned WT message,
in view of the Supreme Court.
in view of the Supreme Court judgment.
No, what
banning-
Mr. Talukdar is suggesting, possibly the provisions of the earlier Jallikattu will remain. And the subsequent judgment was only when some state acts providing for Jallikattu was challenged. And the Supreme Court said that it is constitutionally valid, meaning thereby, if the state intends to allow these activities by means of a state act, then
Under
There
this
will not
thing,
be any.
but if the state does not bring, what Mr. Talukdar is trying to say, that in Assam we do not want to allow it, then the provisions of the earlier Jallikattu judgment will prevail. I think this is his submission.
Yes.
You examine,
Lordship will
we'll hear you, both of you.
Because there is an observation made that animals do not have any fundamental right.
No, we'll hear you, both of you, in detail, no difficulty.
I'll place it.
And that double marking, whatever.
Double marking, my lord, ultimately lordship has directed an inquiry. Inquiry has been done, report we have submitted. We have also given a copy to the petitioner. My lord. Now the petitioner.
What kind of relief can you give him?
My lord, it was a process initiated in the year 2008. All the posts are
Still,
filled up now.
But he is continuing,
Now,
he is continuing with the challenge. There is no delay.
Now, after, this is a 2017 petition, after he obtained the information on the RTI.
Sorry,
Those posts are also not available at this stage.
but then illegality had been meted to him. How that can be?
I'll place.
See,
Lordship,
when an illegality had been meted to a person,
Lordship.
the person is before the court and the illegality is writ large or it is accepted and admitted, then there are two ways out. One, you remove the illegality. The illegality can be removed is that his candidature rejected because of somebody making double thing should be mitigated.
No, his candidature was not rejected. In fact, he secured less marks.
Definitely.
Those were, and my lord, this is.
Mr. Nath,
Lordship.
don't go into so strict technicalities. His candidature be rejected by putting him below in the merit list.
My lord,
Huh.
in fact,
So-
in the process,
Every question did not be so immaculately and perfectly framed. He is rejected because he came down in merit. He was given less marks,
yes,
and that is because of an act by the somebody within the respondents. So an illegality had been meted to him. How do you redress that illegality? One, either give him the employment. If you cannot give him the employment, monetarily he should be compensated
Lordship, that.
so that he can, with that compensation, he can look out for some other livelihood.
Look, for that, Lordship.
But we
at
cannot
least-
say
at least, Lordship,
that illegality is recognized, but no relief for you.
in fact, my lord, in that particular process, he is not the only person in whose case it was happened. It has,
But he is before the court.
no, earlier-
Others had abandoned
yes,
their
yes,
right.
other persons were also before this court. Those petitions were, my lord, considered by the honorable court. Writ appeals were also there. Will definitely.
Dismissed.
Lordship, dismissed, my lord.
But in the facts of that case,
Correct, Lordship will definitely consider.
Facts of that case cannot be superimposed in the facts of this case.
Malad, Same, malad, similar, malad, double.
Think about how you want to
If-
mitigate.
If Lordship ultimately hails that double marking is attributable to the authority, then Lordship will definitely.
Or else,
in the NPL report.
or else.
It is not admitted.
No,
Nothing is
or
admitted.
else, Mr. Nath, double marking is to his detriment. Okay. No candidate is expected to do that something to his detriment. Every candidate endeavor is to succeed in any examination. If the double marking is existing on fact, it is a knowledge within the respondents how it had happened. So if you apply 106 of the Evidence Act, the burden is on the state respondents now to show, if it is your case, that he himself had done it. If you discharge that burden, we'll dismiss his petition.
In fact, my lord, immediately the exam, when the exam is over, immediately copies were sealed. Those were sent to the examiners. Ultimately, my lord,
So if that is your submission, the problem is even more serious against the
no,
respondent.
Lordship will definitely.
Then
examine.
who had broken that seal?
Lordship
do
will
it?
examine, my lordship will definitely.
It's
decide.
more serious against you.
But the benefit of appointment at this stage cannot be given.
If you don't give, you compensate him
No,
for
but-
violating his legal right.
but, then, my lord, the guilt has to be attributable to somebody, my lord. Ultimately,
It is for you to find out who
No,
had done it.
for compensation, my lord, how, my lord,
No.
26, my lord,
See,
that will be.
Mr.
that will
Nath,
be-
for us, it is a very easy proposition.
Lordship,
Compensation by the state.
lordship.
State can recover it after finding out who had done it. Be ready for something in that nature,
Lordship,
or else you contest it, that we did not do.
lordship.
You discharge the burden under 106 Evidence Act. It is not we, it is he himself had done it.
Lordship, lordship. Lordship,
On the next day, we'll hear you.
Yes, yes.
May I just, may not be 25th, madam, maybe a date just after the.
All of you take a common date because
Yes, madam.
this is not a regular bench. We cannot sit almost every day. It will be
In that case, madam,
incorrect to ask the registry
it will
for
be
that.
25th of July.
So whatever date is taken, take one date
Yes, yes.
Hearing date. Oh,
20.
for convenience of everybody.
yeah,
Lordship,
no, it's all right. In that case, it's.
Lordship should kindly have a look at the last order, matter. 18/5/23. So one page order, I'll have to read it, my lord. Because Lordship would recollect, in Supreme Court, we made a statement that as per the 2000 bylaw, we are entitled to 80%, and they said, my lord, it's the 2014 bylaw which should prevail, and in terms of.
So
which-
now the issue had boiled down, which one will be applicable?
Yes. My lord will kindly have a look at this order, my lord. Now, they say that certain portion of 2000 applies and certain portion of 214 applies. 2014 applies, which your lordship has recorded in the order.
As
If your lordship would kindly have a look at the first subpara after the quotation, a reading of the extracted portion of the communication of the director makes it discernible that although uniform zoning regulation 2000 is operational, even after publication of Assam notified areas other than Guwahati building by rules 2014, but regarding regulations related to parameters of the building construction, such as FAR, coverage, setback, building, height, size of plot, parking norms, penalty, etc. Provision of existing building rules bylaws are followed, meaning thereby the rules of
So
2014.
that judgment regarding legislation by incorporation was relied upon.
That was.
Oh.
Well, legislation by incorporation cannot be in the form of a letter of a director. Legislation by incorporation has to be, my lord, by the legislature itself or by the subordinate legislating authority. It can be by the executive. My lord, that is the legal position, my lord. I have one submission to make, my lord, today. Now, our client has, instructed us to make a submission before lordship. Well, there is an adjacent land
near the existing building, which we propose to buy.
Once you buy, your area will
Then,
be
my
more.
lord, my whole thing will become
So you
compliant.
want some time for that.
Yes.
For buying, that's a different
No, not a bad idea. Then what will you do? He'll make it one,
That the composite one. and
one
whatever-
plot.
uh,
And then this,
Eventually, they will decide.
no, after that it is done,
Hmm.
then you take your decision.
Uh,
The total area ratio may be satisfied,
uh.
but whether the side and back satisfies or not, you
That
take your
everything they
decision,
will take it.
whichever way you do.
The question would be, once, my lord, they have violated the entire thing, your lordship has also passed the judgment in that regard. Now they have tested their luck before the appeals court. Appeals court has said,
No.
whatever submission they have made, if there is any truth in it, then they can file a review petition. That is the position. my lord.
No, review their filing basically on the applicability of
Of
whether
which regulation?
2000 or 2014.
Yes.
That decision will take,
Yes.
which one of the two will prevail. But otherwise, the review is also a continuation of the earlier proceeding.
Yes.
Even if there is some aberration of law during the currency of the proceeding, if the person violating the law takes necessary steps
Hmm.
to
Corrective
ensure that the
steps.
law is no longer violated,
Hmm.
that fact can always be taken note of.
Now, your lordship will look at what is the total area. Now, the.
Yeah, suppose, understand. Let us take a different example. This one. Suppose the violation, alleged violation is that you owe 10,000 rupees to the authorities, you have not paid. A litigation is initiated on that issue. During that proceeding, the person goes and says yes, or offers to pay, or says that no, I have paid that 10,000 rupees. The original cause of action goes before the proceeding could be brought to its final end. Following the same principle, suppose now as a review is supposed to be a continuation of the earlier proceeding. During the proceeding, the cause of action of the violation is taken care of. Can you not take a look into it?
Whether they purchase a different land or not is a totally different issue.
No, suppose they purchase.
My-
Suppose in case tomorrow they produce a document, yes, the adjacent plot of land is also now mine. I am converting it to one plot of land. I am making all the applications. So that will render the ultimately these are
Regulatory measures. my
these
lord.
are building violation of building laws. Why are the building laws brought in? To ensure some kind of public safety.
Yes.
That's the only purpose. Otherwise, how does it matter to the authorities what kind of structure you are building there? How many inches of land you have left out of your plot? Otherwise, it's all nobody's concern. It is your land, your house, you build in the way you like. Only thing, the public safety element is there, and therefore there are zoning regulations, building laws regulating the building in a particular manner. Once there is a change of circumstance that because of the subsequent act, it falls within the permissible building law limits, then that building is no longer an illegal.
The building plan already been sanctioned. In terms of that, they have.
No, that will have to take your call. It's
Right.
not that we are going to clear him here only.
Eventually, the call will be taken by
Ah.
them.
He will only go with his added land
Yes.
and make an application.
My lord, I understand that.
Then you pass your order whichever way you like.
Mr.
But in
Chaudhary,
this case, only thing, the earlier demolition order to be not given its effect.
only thing, my lord, what I understand, Mr. Chaudhary is trying in that line is okay. But I have doubt on my client also,
Uh,
because they may be with that side. Because your lordship has interfered, it has come.
No, we are not going to interfere. We'll only give him liberty to
Yes.
file the application.
No, I'm not saying
Uh,
about this.
And what
will
we'll
happen?
provide is upon making such application, whatever is order is passed by the municipal authorities, that will prevail over their earlier order.
Yes.
If you say we reject it, it is our earlier order, then everything remains. In that case, we'll also provide that our earlier order, which is sought to be reviewed, will also remain. But on the other hand, if your authorities take a different view, then it will prevail over the earlier demolition order, as well as our earlier order in the writ petition will also be not have its effect.
So for taking time, my lord, I don't have any objection. I leave up to your lordships. But my lord, that fact may not be mixed with this.
We'll hear you on that.
Yes.
But otherwise, any violator anywhere, unless suppose it's a violation like one man kills another person or some that kind of a violation of law, especially the procedural laws, violation of any procedural law, that can be rectified.
Can I just give
On
one example?
principle, on principle it can be. Otherwise, many cases will have to say, suppose this, you are referring a number of bank surface matters. Many matters,
My lord, it is
Upon
something
the-
like taking away the basis of a judgment. My lord, that's a concept lordship knows, my lord. In a validating legislation, what happens? Supposing a judgment is rendered saying this action is bad on account of XYZ reason. Now, XYZ reason is the basis of the judgment. By subsequent legislation,
that
that basis can always be taken
taken
away.
away.
So this is not something which is not known to the judicial system. So all that we are trying to do is, my lord, we are trying to take away the basis of the earlier finding. If our land is more, then I will entitle to more FIR. In which case, my lord, my land will be locked.
I don't think that is going to help him. Legal.
land, the purchase of land.
Yes.
That we don't know. How much time will you need to purchase the land?
He says, my lord, because there is a procedure of applying 3 months.
But 3 months, can we adjourn it?
No, lordship will, in between, lordship will,
If we
List
don't
in once.
adjourn, the hearing will be completed.
my lord.
This same plea, now we'll
lordship
have
will-
to,
For the present, lordship will give us 6 weeks time.
no,
my lord.
no, suppose we proceed with the matter. If it is in your favor, well and good. That's the end of your problem. If it is against you, you'll go to Supreme Court. Supreme Court, you raised this issue that in the meantime, my purchase of land is.
We can't go this time, my lord, because Supreme Court has not given us liberty to go to Supreme Court again. This is the last opportunity, my lord.
No, no,
This order of the Supreme Court. my
it's
lord.
there, that
Yes.
restriction is there.
Yes, my lord.
Where is it?
Yes, I'll show, my lord.
Normally, once
Order of
a
the Supreme Court is at page 48,
review is allowed to be made,
page 49, my lord,
49.
page 49.
Supreme Court has given a caution to them.
That being the only point, we are not inclined to interfere under Article 136 of the Constitution. But give
What-
liberty to the petitioner to move a review petition indicated on the aforesaid submission.
49 in the writ
No further liberty is given to come back.
Review.
Review petition.
Review petition.
Yes.
Item number 3.
Oh, এখন PL এখন review খন দিয়া।
Review 166.
My lord will kindly come to page 48. Learned senior counsel for the petitioner contends that maximum coverage permissible is 80% as per the norms and not 40% as per the zoning regulation dated 12/6/2000. And thus there is a factual error in the judgment. If that be the position, it is for the petitioner to try his luck in review application before the High Court. That being the only point, we are not inclined to interfere under Article 136 of the Constitution, but give liberty.
Oh,
to the
this
petitioner.
one, no further liberty is
Yes.
given to come back to this court.
Ah.
Liberty is not given, but what about your right?
My lord, that is what I was told, but that's the practice there, my lord. Because once an SLP is filed, if it is disposed of on these lines, my lord, then unless a liberty is given, we cannot go back again. So therefore, this is our last point.
My lord, your lordship also see one line. but give liberty to the petitioner to move a review petition predicated on the aforesaid submission. So if
Aforesaid.
this
This
submission
is
correct-
therefore, we are interested to hear
Ah.
only whether it will be 2000 or 2014.
Exactly.
Yes,
That's all. We don't want to expand our scope beyond that.
yes, yes, yes.
Only thing, suppose we accept it is 2000, the implications thereof will follow. If it is 2014, again, the further implications of 2014
Right.
being in force. And if the implication of, suppose it is in favor of 2014 and the implication of 2014 is at a variance with the judgment of the writ court, then accordingly it has to be suitably modified.
Yes.
This is the limited.
And
area.
this is what we are going into,
Right.
nothing beyond that.
So
My lord,
therefore-
all the matter after 6 weeks, my lord, let us see how we progress. In any case, vacation is intervening, my lord. 4 weeks will go as such. 2 weeks on this
Totally
side.
hypothetical basis, my lord, he will purchase and make the thing regularized. That's a really something.
No, we are ready, my lord.
Mr. Dotto, I remember hearing some of the initial submissions, either by the municipal board or by the petitioner, I don't recollect, that this man is a very powerful man who can do anything.
Yes.
That was one of the initial submissions
Yes.
with which these proceedings started. I think you made it, most likely.
Possibly it came from me, my lord.
He's a very powerful man who can do anything.
Yes.
So if we go by that submission, purchasing a plot of land for him may not be an impossibility. But otherwise, suppose listen property. Or one person. He has some right over his property.
Yeah.
Only thing, the property has been made in such a way that it is in aberration of some procedural laws. Otherwise, it is not illegal. Had the Money Laundering Act or something would have been applicable, we would have taken a totally different view. Now, how you are going to regularize all this? But this is only a violation of procedural law that you must leave this much of space. Your building must be of this size if the plot of land is this much, and that's all. If that problem can be taken care of by purchasing some additional land, otherwise there is no illegality with this building. It's a, there is no
it's not that
safety issue,
without
there is no fire issue, there is no any other issue with this building.
Now, what happened in this case, my lord, your lordship will look at compounding and compoundable offense, non-compoundable offense. Now, what he did, compounding, we do it when we find it accidental, or sometimes, my lord, while making construction. Accidentally, it may be where I should keep 3 feet. I have kept 2 feet. So these can be compounded. Here, my lord, where he is required to keep 5 feet, he kept only 1 feet. And where he is required to keep 30 feet, he has kept 7 feet. Now, these are not
No,
accidental
that's what
by
we
any
said.
means.
That's what my elder brother has said, that if the building was dangerous to life
Right.
by the manner in which it was constructed, perhaps it cannot be compounded. Here
Yes.
the issue is about the front area, back
Some
area.
setbacks. And my
No,
lord, if not, we have already.
Suppose he purchased a plot of land,
Ah.
that will improve his proportion of the building size
Yes.
vis-a-vis the land.
Yes.
It is not going to improve his back setback or his side setback. That he will do separately, how you do.
That his client is thinking that, but it will not. Here, my lord, the plan has taken that what is the coverage, total coverage area.
Ah, so he'll be protected only by the total coverage area after purchasing additional land.
Exactly.
What will remain of the side setback and back setback, that will be again
Everything has
open
to
for
be
you.
worked out new,
You have
because
to,
now land size will become more.
no, it will,
My lord, that's a
it will be
different
open
type
to
of
you.
bills. Your lordship will delete in appropriate time.
And we are not going to provide anything other than if you purchase the land, you go and make an application.
Yes, that's all.
And once he makes an application, the board will apply its own laws, apply
And
its own
consider
mind
it.
and pass an order. If the order is in his favor, we'll say that the earlier demolition order and the earlier writ court order will not prevail any longer. If it is against him, all the earlier orders will prevail as if it was not interfered. Only this much. And the entire onus is on you.
Yes.
We are not, we'll not be deciding anything.
Yes, at this stage, your lordship will only adjourn, no need to say all this.
Today, John, but later on also,
Right.
we are not going anything beyond that.
Yes, yes.
That's all. You consider his that change circumstances,
All right.
how the law will now be made applicable, that's all. Mr. K. N. Johri, as head of counsel for the review petitioner, has made a statement that he has instructions to inform the court that a review petitioner intends to purchase an adjacent plot of land, which in a composite manner may increase the total land of the petitioner. On such statement and has sought for a John to be listed on such.
Third August.
Of life.
We are clarifying that we are neither given any liberty to the petitioner to purchase any land, nor have made any observation on the effect of any such further land if purchased by the petitioner, which shall be subject to further hearing in the proceeding.
Of life.